good morning, everyone. Thank you all for joining us. This is Dan at Unicorn Riot. We're live on day 11 of the Kim Potter trial. We're expecting them to come back into court within a few minutes, hopefully. So it's good to have you all here today. Thank you all for tuning in. I'm going to just play some more from the day of April 12th. We're just going to kind of keep playing through that. We are watching. This is the live feed right now. You can see the great seal of the great state of Minnesota up there embossed on the wall. So we're going to, good morning. Yeah, where are people watching from? You can definitely say where you're watching from. We got one from Atlanta, one from Connecticut. Let's see if anybody else wants to go. So we are expecting today to essentially wrap up the prosecution's case. Formally, the prosecution's case hasn't rested. That was their last witness at the end of yesterday, but they haven't rested yet. We were hearing from Seth Stoughton, who really seems to have kind of pushed everything back towards the state's advantage by sort of laying out a lot of different things about the use of force and how that works. Good morning to everyone. Yeah, Connecticut, Atlanta, Dallas, Iowa, DC, Portland, Oregon, Charlotte, North Carolina, Waukesha, Wisconsin, Minnesota, more Minnesota, Freeport, Illinois. Good morning, Las Vegas. If anyone in YouTube chat wants to say where they're watching from. Kansas City, Missouri, Chiefs Kingdom, Jamaica. Well, hello, Jamaica. It's great to have the international viewership, right? It's great to be able to, push this stuff out. Everyone across the world can tune in, which is very cool. Donnelly, Minnesota. Good morning from good old Scotland, says Scott. Good morning. All right. Over on YouTube, we got Minneapolis. We got Austin, Texas. Let's see. Des Moines, Washington. Very cool. So I just kind of want to go over a little bit. Excuse me. I want to go over a little bit. A lot of this has to do with what a reasonable officer would do and what would be more reckless than what a reasonable officer would do. So it isn't necessarily about like motives. It's a lot of it has to do with like the reasonable officer standard. So I think that that's a good thing to kind of focus on as the prosecutions try to draw the contrast between the reasonable officer and what they're saying, are saying Kim Potter's reckless actions. All right, so we got Arkansas, Shoreview, Minnesota, Hayes, Kansas, North Dakota here, Milwaukee, Wisconsin, Philly in the house, Johns. Good morning from Brooklyn Park, South California, Grand Rising, New Jersey, Austin, Texas, Minneapolis on YouTube. Good morning from Worthing in West Sussex, England. Good morning, Worthing. Columbus, Ohio. So, thank you all for joining us. So we've seen the state try to break down all those different doubts, right? The defense was raising, and now the defense is going to start its case. It could be kind of hard to watch, right? Because they're going to try to, demonize Daunte Wright. They're going to try to act like insurance or cannabis or, any of these different things are a reason that deadly force was reasonable. And we heard from a lot of these state witnesses that they did kind of feel deadly force was reasonable in different ways. And that's going to be important, right? And we also heard in these sort of extended sidebars and discussions where the jury wasn't in the room yesterday that the defense was really worried that the jury was taking so many notes about Stoughton. Like, we can't see what the jury is doing, but they were definitely reacting to Stoughton's testimony in a strong way that got their attention. He was very good at presenting his material in Derek Chauvin's trial. And he did a good job presenting the concepts here and not getting rattled. So the Stoughton element is very important to how this all plays out. All right, so who else we got? Let's see. Columbus, Ohio. Good morning from Chicago, Illinois. Austin, Texas. Kingsport, Tennessee. Rochester, New York. Baxter, Minnesota. Hashtag Justice for Daunte Wright. Good morning from St. Louis, Missouri. and little on YouTube, Little Canada, Minnesota. We know Little Canada, and from someone from St. Paul, but in Rockford, Illinois at the moment. Skull 100. Cool. So, yeah, someone's asking because I mentioned the cannabis case. No, Minnesota is still a pretty hard line. Recreational cannabis is not permitted in Minnesota, and the medical bill. I was around at the legislature when the medical bill stuff was happening, and it was really bad. And it hasn't really moved much since then. There have been small reforms, but it's a very bad situation. So the war on drugs was a big deal in the Philando Castile case. Geronimo Yanez, who had Earl Grey as his defense attorney, was able to wiggle out of shooting Philando accountability because he just said cannabis made him so afraid. So you could definitely see Earl Grey is trying to follow the same track again. But in the light of day, when everyone can see what's happening, is that going to work so easily? Seems like not. So, I mean, we'll see. But, that's what happened before. So, okay, Raleigh, North Carolina. The weather's nasty. Minneapolis. Yes, I hope everyone's safe out there. Portland, Maine, Ann Arbor, Michigan. Hometown, Yipsy. All right, the judge is coming in. Thanks all for joining us.
Okay. Thank you, Deputy. Counsel's ready for the jury?
Mr. Gray will be here.
Oh, okay.
Alabama. I'll have to check in.
I got one back there. I want that.
All right, yes. Okay, please be seated. All right, good morning, members of the jury. I was pleasantly surprised that we didn't have the icy roads that we thought we were going to. So, all right, does the state have any further witnesses?
Good morning. No, Your Honor, the state rests.
Okay, members of the jury, I need you to step out for a couple of minutes, about 10 minutes. All right, please be seated. Okay, Mr. Ng, you had a matter that you wanted to bring up.
Your Honor, the state has now rested. The defense moves for a judgment of acquittal. I realize that the facts are construed most favorably to a potential verdict and consistent with the guilt. On the other hand, the testimony is confusing at best. The theory advanced yesterday is that a taser was inappropriate to be used. That was an opinion of Mr. Stoughton. The testimony, though, has been that the taser was reasonable to be used. So the state has presented witness after witness, either on cross or direct. I'm speaking of Peterson Lucky, for example, who've indicated that the taser was quite reasonable to use, should have been used. I think they were pleased that it was used, or at least something was done. So we have sort of this discordant presentation. I mean, if the theory of the government is that the taser is inappropriate, then they've presented conflicting evidence to that opinion. If the theory of the government is that the taser was appropriate, then the expert's opinion is inappropriate. And that also goes for the use of deadly force as well. I mean, we have Johnson's testimony and Fleshling's testimony, and we have Stoughton's testimony. So it's a confusing mess, really. And I say that in all due respect to my colleagues on the other side. When you denied our motion for the judgment of acquittal on the manslaughter count one, the opinion was, of course, thorough and well done, but it also commented how the probable cause standard is quite de minimis compared to the standard of proof beyond a reasonable doubt. And so they still have to show that, at the moment, and it is a standard at the moment, she thought she was employing her taser, and everybody agrees to that she had a knowledge that she was about to commit a violent act, and with that knowledge, however obtained, disregarded that knowledge. That's really a high burden to meet under those cases we've been talking about. So while the probable cause was perhaps suitable to satisfy both charges, which are related to each other, really, I mean, the consciousness of guilt and the first degree standard are quite similar, the evidence in our view is insufficient. We request that you dismiss both counts, but particularly the Man 1 count, which the court had already discerned is quite weak. And nothing has happened here to make it stronger. I also want to make an offer of proof consistent with what we were talking about yesterday. I can do that now or wait on that. I defer to the court's discretion.
Okay, why don't we let the state respond to the motion for judgment of acquittal first?
Thank you, Your Honor. My understanding,
Sorry.
habits, yeah. Your Honor, the standard for taking a case from the jury's hands is actually quite high. I think the court has to basically issue a summary judgment that there's no way under the set of facts presented to the jury they could arrive at a guilty verdict. It certainly has not been met here. I take it from counsel's argument that the real challenge is to the recklessness or carelessness elements of the statutes. I know there have been arguments made about causation, and I'm sure will be made, but pretty clear the testimony that the court heard was that the bullet that Miss Potter fired into Mr. Wright's chest blew up his heart and killed him within minutes. That's causation. The elements of recklessness, Your Honor, as you know from the jury instructions you've crafted carefully, talks about a reckless handling or use of a firearm for the first-degree manslaughter charge. Here we have a 26-year veteran of the police department who was trained every year in how to handle her firearm and had to qualify every year to handle her firearm, carried it when she was on duty, and yet did not know she had her gun in her hand when she shot Mr. Wright. I think the facts bear that out on her statement alone, which the court and the jury has seen. That is raises the issue of the recklessness of her act. She committed a conscious or intentional act in drawing the firearm. There was evidence that she prepared to do that. She pulled it out of her holster, pointed it directly at Mr. Wright, and fired it without knowing it was her handgun. Can only be said to be reckless in and of itself, and certainly is something for the jury to consider. The second-degree manslaughter charge has culpable negligence, which is that the defendant did not intend the act to be harmful, but that an ordinary and reasonable person would have recognized the actions created a strong probability of injury to others. That is an awareness of the risk and a disregard of it. Again, speaking with respect to the decision to use a taser and instead using her firearm, which really applies also to both counts. She has been trained multiple times over her 26-year career, certified as a taser user since 2002, received trainings that the jury has seen, the court has seen regarding weapons confusion. It was an issue known to everybody in law enforcement. It was taught to her multiple times. She was aware of it, therefore, as the evidence, and by pulling her firearm instead, and acknowledging that she knew about weapons confusion in the sense that she had been trained on a taser. She knew enough to give a verbal warning for that taser. Shows intentional conduct that was done with an awareness of the risk and a complete disregard for the risk. Those are the basic, as I understand the motion, contested elements. There's certainly sufficient evidence. The state did not present conflicting evidence. I think what counsel is referring to is the evidence they led witnesses into saying, which I think where it was impeached. And if there are conflicting pieces of evidence, that's for juries to weigh. So the defense has not established a basis for their motion to be granted today because there is adequate evidence for the case to go to the jury. We would ask the court to deny the motion.
Okay. A judgment of acquittal can't be granted unless the trier of fact could not reasonably find the essential elements of the crime are established beyond a reasonable doubt. In ruling on that motion, all reasonable inferences and the evidence has to be viewed in the light most favorable to the state. That's the standard, and given that standard, I'm denying the motion for an acquittal. A couple matters from yesterday. I am going to allow the defense expert to testify about deadly force. Okay, that was a topic that was extensively covered by the state's expert. There's no prejudice to the state, obviously. to have the expert testify on deadly force, and there really are no surprises on what the expert's going to say. Then, Mr. Gray, I think you wanted to be heard on...
Should I go to the podium?
Yes, please.
Good morning again, Your Honor. Your Honor, I gave you exhibit, I can't remember the number of it. The exhibit is a certified copy of the conviction of Mrs. Wright, the first witness. You might recall, Judge, that before the trial, Your Honor ruled that we could bring up the fact that a felony conviction was, that she was convicted of a felony convictions, and the date of it was within the requirements of the law. Well, the state, in their presentation, said to the witness, well, you were convicted of a second-degree drug offense, weren't you? Something to that effect, which was not the judge's ruling. The judge ruled that you could just say felony conviction. And instead of embarrassing the witness more than need be, we refrained to get up, we restrained getting up and pointing out that the conviction was, I think, about a year ago, that she was convicted of this felony. Rather than do that, we decided to offer into evidence, since they now have presented the conviction, the court knows that they can do that, or we should be the ones that can do it within the time period required by law, that we would have a right to show the date of the conviction, because the jury has no idea when this conviction occurred. So we waited until we presented our case. We obtained, excuse me, Your Honor, we obtained a certified copy of the conviction, which is admissible under the rules of evidence, and it's self-authenticating, and we offer it as in our exhibit. Thank you, Your Honor. Excuse me, I'm sorry. For the purpose of showing that when she was convicted of the felony of drugs. If they're willing to stipulate to that, we don't need it. But if they're not willing to stipulate to the date that she was convicted of this, then we need it to prove it. Thank you.
Okay, you're not going to bring it up in your case in chief, obviously, are you?
No, I need that to show the date that she was convicted.
Okay. Does the state object?
Yes, Your Honor, the state objects. The court's prior ruling was that if Ms. Bryant was other than a spark of life witness, that she could potentially be impeached with an unspecified felony. That's how the court characterized it in the court's order. On direct, the state fronted the fact that there had been a conviction, which I believe was characterized as a felony conviction for second-degree controlled substance possession. That was fronted. Counsel had the opportunity to cross-examine on that point if it desired at that point, if the defense so desired. This issue was not raised at that time. Defense counsel essentially waived any right to cross-examine on that point. We fronted information that went beyond what was required under the court's ruling. That, however, does not supplant the court's direction, which was essentially that under the rules, the court has already decided that extrinsic evidence or other unrelated information about this conviction is clearly improper here. Had counsel wanted to inquire about the date of conviction at the time, I don't know that we would have taken issue with it, but at this point, with no foundation, with no witness, they now want to offer evidence, extrinsic evidence of a conviction that has absolutely nothing to do with the issues in this case, is completely collateral, is completely improper at this point. And we'd object, Your Honor.
Well, Your Honor, it's self-authenticating. We didn't cross-examine her on it because we followed the court's ruling. And what we're doing is attempting to show the date, and the date is shown on that without asking her a question. I was actually surprised when the state asked her, were you convicted of a second-degree drug conviction? I thought that was a violation of the court's rule, of they were convicted of a felony. But they did that. I would not know what she would say as far as the date, because I didn't ask it because of the fact I didn't want to further embarrass her. But we have the certified copy of the conviction. If they're willing to stipulate to the date of the conviction, we don't need it. But if they're not, we have a right to present evidence of the date of the conviction. It's not impeachment, it's our case in chief.
Your Honor, counsel had an opportunity to raise this issue, to bring this issue to the court's attention, to address any questions about date. I have not. I believe that counsel walked in with a copy of the conviction, showed it to my colleague at counsel table, and handed it to the court. My understanding is that document, although I don't have a copy myself, includes a lot of information that clearly does not pertain to the date of conviction. I presume it has information about, plea and sentence and things that clearly are not within the purview of the rule that governs prior convictions. And I do want to point out for the court that the court's original ruling was that there was essentially very little room for defense counsel to even inquire about this. We fronted it because we wanted to do that out of an abundance of caution, the fact of conviction. But other than the fact of conviction, none of this is relevant, Your Honor. And we object strongly.
Oh.
Well, they brought it up, Judge. We have a right to show the date.
Okay. You had the right to show the date at the time that you cross-examined.
Well,
That's
I
right.
could have asked her, but that would have been a violation of your rule about a felony. I wasn't going to violate your rule, even though they did.
I'm not going to let this in.
Could we have a stipulation that would be allowed to stipulate as to the date of the conviction?
Is the state willing to just acknowledge the date of the conviction?
No, Your Honor. There's absolutely no basis for us to do that at this point.
And of course, the state is interested in justice, like they're supposed to.
Okay. All right. That's all right. The admission of this exhibit will be denied. It's marked 1007. Okay, Mr. Frank.
I'm being presumptuous, Your Honor, that I may address the court.
Yes.
I think, as you know, as a trial judge of many years, the certified copy of the conviction is used to impeach the witness if they deny the conviction. It doesn't go in as a substantive exhibit itself. So even the process here is completely wrong. But I understand the court's ruling. I just want to point that out, that it's, to me, it's somewhat disingenuous to say we didn't want to embarrass her then because they didn't want to ask her while she was on the stand and look a certain way. Now they want to do it. Anyway, I'm sorry.
Well, you guys, I think we spent way too much time arguing at this point, which is totally collateral.
Thank you, Your Honor. I'm sorry. Your Honor, I indicated to the court yesterday that we would object to Mr. Imes testifying about deadly force opinion. I raised it so the court would be aware of it, that we would need time, but I do want to address it because I think it goes simply beyond what was raised yesterday about it. Your Honor, we received an order from the court. The court filed back in August, I believe. June 2nd of 2021 with an expert disclosure deadline.
Yeah, I already ruled on this.
But I haven't had an opportunity to be heard, Your Honor, and I think we had an opportunity to be heard. That's why I fronted it yesterday to say we need time this morning to address this. But as you will also recall, well, maybe you don't know this, but Mr. Eng and Mr. Gray were going to meet with Mr. Imes last night. We have an additional disclosure. And so I want to address this because what we have here is flouting of the rules in the court's order. And the prejudice comes from not knowing what this witness is going to say, not what we know our own witness is going to say. So I would like to address that, Your Honor.
I'll let you continue. I didn't let you argue this morning on that point, but go ahead.
Thank you, Your Honor. The court's order required and cited to the rules of criminal procedure that require it as well, that disclosures of experts would be made by October 15th of 2021, and any rebuttal to those disclosures would be made within 30 days. The disclosure required all findings, opinions, or conclusions to which each expert is expected to testify and the basis for their findings, opinions, and testimony. Purposes for that are obvious, so that there is notice to be prepared for trial so the opponent can fairly meet the evidence that is going to be presented. As you recall yesterday, Mr. Gray objected because the witness had used one word, subjectivity, or subjective, that he couldn't find in the report. And at that
Actually,
point,
that is what I brought up, not Mr. Gray. Okay.
he brought the objection up, and the court asked that. And what the court had said at that time, if it's not in the report, you're not going to allow it for testimony. Your Honor, here is our expert's report. It's 52 pages long, single-spaced. It's very thorough. It has captions, headings, opinions, explanations, the basis, all set forth in these 52 pages. The report that was disclosed to us from Mr. Imes is a little over 2 pages long, Your Honor. The opinions in it really encompass less than 1 page. Most of them, in fact all of them, are very conclusory and simply state in one sentence an opinion. No basis for that, no discussion of what they will testify to support that opinion. I believe you have a copy of this. You're familiar with it. It is, to say the least, conclusory. The disclosure that the defense provided, Mr. Eng signed and filed, says simply that Mr. Imes will testify that Officer Potter's decision to use a taser was appropriate and consistent with standard training police procedure. Nothing about deadly force or the use of a firearm. Your Honor, before trial, when we met with our expert witness, this is a copy of what we disclosed to the defense. It's thorough, and according to Mr. Eng, painfully thorough, 4 pages long, single-spaced, with a complete description of our conversation with the expert at that time, or complying with disclosure requirements about what our witness will testify to. Last night, I received an email from Mr. Eng. He sent it at 7:24 p.m., but I didn't see it until about 9:30 p.m. because I have a home life, right? I get to go home and have a home life, so I didn't see it till 9:30 last night. It contains 6 sentences, 6 numbered sentences. I'm sorry, one is actually 2 sentences, but in 6 numbered lines that are single, conclusory statements about what Mr. Imes apparently is going to testify about. No explanation of the bases for that or what else he will testify about. So what we have, Your Honor, and yesterday, and I have a copy for this if the court would like it, and so we have been given no knowledge, no information about what Mr. Imes is going to rely on to support his opinions. We just have these conclusory statements. There's nothing in the reports or this follow-up about his basis for the deadly force opinion. We disclosed our expert's report that has 3 or 4 pages on deadly force back in October as we were supposed to, and they were clearly on notice then that deadly force was an issue. They requested a jury instruction on deadly force, and yet we're getting disclosures about a deadly force opinion on the night before this witness is supposed to testify in the morning. Your Honor, this relatedly, the defense intends to call Tim Gannon today. The disclosure we got from Tim Gannon November 8th is provided by defense counsel when they met with him. It's a page and a half, and it is woefully inadequate. And just sort of interestingly, like the very first paragraph says we talked with him about his education, his law enforcement career, working relationship with Officer Potter, mentions that she was the union representative, and then just says, were summarized. So rather than telling us what information they got, it just says that it was summarized. We didn't get the summary. It goes on, Your Honor, to present very conclusory statements. The close proximity of her taser to Mr. Wright was not concerning under the circumstances presented, period. No basis for that opinion, no foundation for that opinion. Goes on to say her assumed use of the taser was reasonable and appropriate. No explanation as to the basis for that opinion or why he would offer that opinion. Then, Your Honor, we got a disclosure from an interview with Mr. Gannon on December 6th of 2000, so after trial had technically started, where he now, Mr. Gannon will offer an opinion about deadly force. Little to no explanation of the basis for that opinion, his foundation for that opinion. And so, again, what we're getting is they didn't have an expert talk about deadly force. Now they're trying to turn a former police officer who worked with Ms. Potter into an unnoticed expert witness who's going to offer an opinion in violation of the court's disclosure order and without what is required by the rule in the court's order as to disclosures for such opinions, even setting aside whether it's appropriate for a lay witness to offer a legal opinion as an expert. We followed the rule in the court's order to disclose our expert. Now they're trying to slip in somebody because they didn't. What we're seeing, Your Honor, is a pattern of flouting the court's orders and the rules and trying to litigate by surprise, not doing proper disclosures, not doing full disclosures, and just putting up a witness without letting us know, being able to fairly meet that testimony. That's not what the rules provide. Your Honor, and this is not, Your Honor, ineffective assistance of counsel. I am not concerned about that because this is strategic, this is tactical, this is effective assistance of counsel. They are trying to represent their client in a way that the rules don't provide, but which gives them an advantage. We are asking, Your Honor, to not allow Mr. Imes to testify at all because the proper disclosures were never made about the substance of his opinion, the support for his opinion, including the disclosure made last night that I, again, saw at 9:30 p.m. At a minimum, he should not be allowed to testify to anything, as the court said, that is not in his report. We don't expect that every word a witness says on the stand is going to be in the disclosures, but we expect the substance of it to be. I think the court recognized that yesterday in first raising the concern and then recognizing that the substance was there. And so what we're being required to do today is litigate without proper notice provided by the rules in the court's order. So we are asking you to prohibit his testimony, Mr. Imes, at a minimum to limit it to exactly what is the conclusions in his, the only disclosures we got. And with respect to Mr. Gannon, first of all, to not allow an expert opinion. We have objected in the past to allowing lay witnesses who are fact witnesses to come in and testify to opinions. I think the court's ruling was that they could testify that what Officer Potter did was consistent with their training. We still object to that, but we more strenuously object to allowing them to offer an expert opinion about whether it was reasonable. It's a legal conclusion. It's subject for an expert opinion, as we have done, not for sneaking a witness in to do it. And we would ask the court to not allow former Officer Gannon to testify to his opinion about deadly force. So that is our motion, Your Honor, this morning. And unless the court has questions, I'll leave it at that.
Mr. Ram, did you want to respond?
Well, we had a discussion about this yesterday in terms of Chief Gannon, former Chief Gannon. He's a lay witness. He's not an expert witness. He has more training at 25 years than Mr. Stoughton at 5 years. And, we met with him, and, the state finally gave us their voluminous jury exhibits. He showed him a couple more exhibits than he had. And we asked him, what his view of it was. And you've already ruled that he's qualified. If they have a problem with Mr. Gannon, they could have called him. I mean, he certainly would have interviewed with him. They didn't make any attempt. In terms of the Iams testimony, we believe in brevity rather than a 50-page report. Mr. Iams is not charging us anything. I gave a detailed summary. There was no objection to it. They never complained about it until today. We did meet with him last night to go over the Stoughton testimony on the points he would disagree with. And as I mentioned yesterday, an expert's entitled to listen to the whole trial, and he has listened to the critical evidence, namely Lucky Johnson, the trainers, and Stoughton. The rest of it's kind of fluff, really. DNA, really? Firearms evaluation, really? And so he has, 98% of what I was going to ask him was about the taser, but, they've opened the door here. The Stoughton testimony, and particularly the Johnson testimony, is critical. He was unaware of it, and so he's going to answer it. And it's not going to be extensive. But I find, there's no prejudice to them whatsoever. We just got 3 hours of Stoughton. I'm going to get a little bit of time on Iams. And again, if they had a problem with it, they should have told us about it beforehand, or at least called him. I mean, he's quite accessible, as you'll see. So, it's much ado about nothing, and we appreciate your ruling. It should stand. I mean, this is the pattern that the state repeats over and over again. They don't get a ruling. They spend 20 minutes lecturing you on why your ruling's wrong. And then here we are at 9:40 when we're ready to go. So we're ready to go.
All right. Let's deal with the expert first. I am going to allow the defense expert to testify about deadly force. Mainly because there's really no prejudice here. The basis of his opinion are the facts in the case. And generally speaking, the facts in the case are really not in dispute. So, absent prejudice to the state, and I think it's legitimate to have a defense expert respond to claims that were made during the trial, I'm going to let him testify as to deadly force. With respect to former Chief of Police Gannon, I previously ruled that police officers could testify that conduct was in accordance with their training. I also believe that the chief of police in this situation should be able to testify whether or not, under the facts presented, this was improper, inconsistent with Officer Potter's training, and unreasonable force. He's the chief of police. I mean, I'm assuming he got that position because of his training and his knowledge of what is or is not proper to do as a police officer. Okay, let's get the jury in. Thank you, Deputy. Oh, excuse me. Can you tell the deputy to hold up one moment?
He's right there.
Oh, okay, just one moment. I just wanted to cover one thing. Ms. Potter, do you still want to testify, or have you changed your mind?
Yes, Your Honor, I'll testify.
Okay, and you don't need any more time to think about that?
No, Your Honor.
Okay. All right,
Your Honor,
Deputy.
excuse me, for the record, we have talked at length about that.
Okay.
He wants to testify.
All right. Okay.
Can I get my witness too?
Yes, please.
Thanks for joining us, everyone. So the defense is about to start its case, and the defendant, Kim Potter, did just confirm that she is going to testify in her defense. I was not sure about that earlier, but it's confirmed.
Okay, please be seated. Members of the jury, I apologize for the delay in getting started this morning. I had to deal with some legal issues. And I want to also explain to you that yesterday there were some times that we had headsets on. We were discussing legal matters. We're not trying to hide anything from you, so I hope you understand that. But it's very important that you only consider evidence that is properly before you in rendering your verdict. So I know it can be frustrating, but I want to be careful, and I want you to consider the right evidence. Okay? The state or the defense may call its first witness. Yes. Come forward, please. And would you stand behind the witness chair? And raise your right hand. Do you swear under penalty of perjury that you will truthfully testify in connection with this case?
Yes, ma'am.
Please take the witness chair and please remove your mask. State your full name and spell it.
Stephen Bradford Imes, S-T-E-P-H-E-N. Bradford is B-R-A-D-F-O-R-D. And the last name is I-James, I-J-A-M-E-S.
All right. There's a court reporter taking down everything that's being said, so you have to follow certain rules. You have to answer yes or no instead of shaking your head. No, uh-huh, or uh-uh. If you don't understand a question, let the lawyer know. Only one person can speak at a time. So wait until the question's finished before you answer. And most importantly, if an objection is made, stop talking immediately. Do not answer the question unless I tell you to.
Yes, ma'am.
Counsel?
Thank you, Your Honor. Mr. Imes, how old a man are you?
I'm 64, sir.
Where are you from?
Springfield, Missouri.
Did you drive up here yesterday?
Yes, sir.
Tell us about your education, your undergraduate degree and a master's degree.
I have a bachelor's degree in criminal justice and a master's degree in public administration.
And do you remember when you got those?
80s and 90s.
Okay. You've had a career in law enforcement, have you not?
I continue to be commissioned as a Class A peace officer in Missouri today, yes, sir.
How many years have you been a police officer?
I'm in my 44th right now.
Okay. Have you attended, in the course of your career, certain law enforcement academies?
Yes, sir.
Could you tell us what those are?
Initially, the Missouri State Highway Patrol Academy, and then the Springfield, Missouri Police Academy, which is an internal 1,000-hour academy. As for basic police training, that's the two initial academies I went to.
Did you attend the FBI Academy?
I'm a graduate of the 186th FBI National Academy, yes, sir.
Could you tell us a little bit more about that? Where did that take place?
It's in Quantico, Virginia, and it's considered the premier training for law enforcement managers and commanders in American policing. We also do foreign countries. I think there's been 117 countries that have sent senior police commanders, but it's primarily an American police finishing school for commanders.
Have you been to the DEA Academy as well?
Yes, sir. Graduate of the DEA Academy also.
And what was involved in that?
That was a 2-week commander's academy simply for running drug schools, drug programs, basically a focused command effort to teach you to do a better job of doing safe and effective policing in a pretty complicated area of the drug world. And that's what
I suppose we ought to say what the DEA means in terms of those initials.
Sure, Drug
is
Enforcement
DEA?
Administration.
Okay. All right. Let me ask you what your specific experience is in law enforcement and a number of your other qualifications before we get to this case. Tell us about your law enforcement career. How did it start and what did you initially do?
As with almost every police officer, I started as a basic patrolman, driving a patrol car, answering calls, just your general call for service. Promoted from there to a narcotics drug investigator, and then from there to just a general crimes investigator, your basic TV detective. I left a smaller department after 3.5 years, primarily to get my 4-year degree. I moved to Springfield, Missouri from Poplar Bluff, Missouri, and went back through the academy. Policing is unique, in some ways good, some ways bad, but it's not a profession by many standards. For example, when I moved from one department to another, I went right back to school. It wasn't like since I had been a police officer, I just come to work. So in Springfield, regardless of my detective experience, I went right back to the academy for 1,000 hours and then 13 weeks of riding with a training officer.
So
And
let me
then-
back up. Did you start out with the Poplar Bluff Police Department?
Yes, sir.
And then after a certain amount of time, you went to Springfield, the Springfield Police Department. Is that
I was in
correct?
Poplar Bluff for about 3.5 years, and then to Springfield, was there for 25. I retired there as the assistant chief. But the beginning is right back to the street. So I did several years as a patrol officer after the academy. I rotated in to work the jail for 9 months. We had a 14,000 prisoner a year jail booking process that if we were short on civilians, they would grab the low senior people. So I did 9 months in the jail. I dispatched for a while, worked the front desk. You just do whatever they tell you to do in the early days, especially.
Did you advance through the department?
Yes, sir.
Tell us what your advancements were.
After several years in those assignments I just mentioned, I was transferred to an undercover narcotics role, where basically bought hand-to-hand drug buys off about 300 suspects. Ultimately promoted to a detective corporal, which is a plainclothes investigator, kind of what you see on TV, doing every type of post-event investigation, robbery, homicide, theft, that sort of thing. Ultimately promoted to sergeant in the detective division. And then in 1989, a catalyst event, a pretty catastrophic hostage-taking scenario, resulted in us creating a full-time SWAT team versus a part-time team that would not be as practiced and experienced.
What's a SWAT team for our own?
Special Weapons and Tactics is what the terminology references, but it's basically a group of officers. It varies by department, but for most it's an elevated skill proficiency group that focuses on really critical incidents, day in, day out, your drug search warrants, barricaded suspects, hostage takings. And we had an event that finished well, but it wasn't because we did well. We had a hostage taking that finished successfully, but because the suspect allowed the victim to be released. And the chief recognized after that that we simply didn't have the capability as a part-time team to solve it. And so he created a full-time team. I was asked to lead that team. And when I say full-time, just to be clear, most SWAT teams in America, about 98%, have collateral duties. They work in patrol, they work as a detective. In our environment, it was the only job we had, 10-hour training day a week, and nothing but search warrants, barricades, and the rare hostage taking. So I had that team for many years.
About how many, do you remember?
As the direct supervisor, first line person, 89 to about 94. I kept it in my division as command almost to the last day I was there, but functionally, once you make captain, you're not an operator anymore. You need to allow line people to work. So once you're at that level, I stopped doing the day-to-day work with them.
And what other responsibilities did you have after that with the department?
When I promoted to lieutenant from that division, I kept supervision of SWAT, but I also had narcotics. So you had all drug investigations, all special operations, K-9, bicycle unit, just odd things that police departments lumped together. Ultimately promoting to a captain and took over the uniform patrol division, which would be everything you see in a uniform, from a DARE program, drug abuse resistance education, to uniform patrol, to a school crossing guard, just everything you think uniform policing. About 3 years later, I think I was promoted to major and took over all investigations, which would take you out of uniform, but then anything, plainclothes, narcotics, robbery, homicide, anything that would be your perspective of a plainclothes detective. And I had that role until I retired as the assistant chief.
Along the way, while you were at the Springfield Police Department, did you work with the United States Marshal's Office?
I was a commissioned marshal on a number of task forces at various times in my career. There's reasons why agencies do that, to give you a different level of authority. And there's also some funding reasons why you do that. You can get money funneled to a department to help with overtime and things like that. But on a number of occasions, yes, sir.
Did you also work on a DEA task force while you were at Springfield?
On a number of them, yes, sir.
You indicated that you were a licensed police officer for 43 years. Have you considered now retiring from active duty, so to speak?
As recent as 2 months ago, I was driving a marked patrol car for the State Park Police, the Park Rangers. I'd done that for the last 3 years. Had some medical hiccups that have caused me to resign that commission, but I'm not sure what will happen after the first of the year, but I'm leaning more towards family stuff. But
well,
we'll see.
You've come up here in a car. Did you recently have heart surgery in Chicago?
Open heart surgery last week.
Okay. All right. Which is one of the factors you're considering in retiring.
My wife's certainly considering that, yes, sir.
Okay. Do you know what a critical incident is?
Definition varies from agencies. There's no national standard definition, but for most agencies, it's an incident that involves an enhanced potential for death or serious physical injury over your ordinary day-to-day call.
In your 43-year career, how many critical incidences have you been involved with?
I couldn't begin to answer that. I mean, it'd be many, many, many.
Can you give us an estimate?
Hundreds.
And were some of those critical incidents involving guns and shots fired?
I would say the vast majority, not that you can't be in immediate deadly jeopardy with something besides a gun, but normally, because the gun issue involves distance and capability, you can usually stay away from a knife person to some degree, but most of them involve guns because they're harder to control.
Do you have any teaching experience?
Beginning in the late 80s, I became a generalist and specialist instructor for the Missouri Department of Public Safety and began just teaching in Missouri, primarily drug-related investigations, and then as our SWAT team evolved, began doing SWAT training. Not because, we were the best, but we were busy and we had good outcomes. We were able to get the job done without anyone getting hurt. And in policing, you quite often look to others who are doing something that seems to be where you want to be, and you learn from that. So we began doing a lot. I began doing a lot of tactical training. There's an international organization called the NTOA. It's the National Tactical Officers Association, but it has 40 countries represented. Began teaching for them. In the late 80s, early 90s, we began videotaping virtually everything we did, which in American policing, that was just stunning, that you would videotape what you were doing, and many, many people question the logic in that. For us, it was primarily a critiquing, learn from training perspective, but because we had video, of operations, of things going well, things going bad, it greatly enhanced the teaching capability. So I could show videos of actual operations. One thing led to another, and I was asked by the director of the NTOA to be one of their 4 national board members. So once I became on the board, a key part of that was teaching for the National SWAT Association.
Well, let me interrupt you then. Let me list a couple organizations you've taught for, if I may. Have you presented for the United States Department of State?
In 33 countries, yes, sir.
Have you presented for the International Association of Chiefs of Police?
Many, many times.
Okay. You've made presentations in many states in the United States, have you not?
Yes, sir. I think pretty much everywhere.
Okay. You have made presentations on the international arena in Somalia?
Yes, sir.
Haiti?
Many, many times in Haiti.
You've made presentations to SWAT officers in London, Amsterdam, Brussels, Dusseldorf, Nuremberg, Belfast, among other places?
33 countries, yes, sir.
You've made presentations for the United States Department of Justice in Bosnia?
Yes, sir.
You've also worked as an evaluator for various countries and how they operate their police forces and their SWAT teams. Have you not?
Not unique to foreign countries. I've actually done more evaluations here in the United States. That's actually a key part of what I've done, especially in the last 10 or 15 years, is do evaluations for agencies that would just like an outside external perspective. In some cases, after a tragedy, a critical incident, but in some, they'll invite you in and say, hey, I've just taken over this department and it looks good to me, but I would just like an outside look, someone who doesn't have a dog in the fight. So I do a lot of that, more in the United States, but I have done a lot overseas, but more here.
Well, let me ask you whether overseas you've worked with various countries, including Jamaica,
Yes, sir.
Canada,
Yes, sir.
countries in Southeast Asia,
Yes, sir.
Tanzania,
Yes, sir.
Greece,
Yes, sir.
Yemen,
Yes, sir.
Kenya,
Yes, sir.
Indonesia,
Yes, sir.
and that's just a start. I can.
Been to a lot of them, yes, sir.
Okay. And you've also trained officers in terrorism and counterterrorism, have you not?
A key focus of the international training, not surprising when you consider the last 20 years or so, post 9/11 for sure, a critical focus of our U.S. government effort overseas that involves local police. A lot of individuals don't understand that much of the American policing effort overseas that the U.S. government funds is done by police officers, not the military. Nothing wrong with the military, simply that our government, I believe, thinks that it's best for police to train the police. And so post 9/11 especially, a key focus of what I've done is under what's called a anti-terror assistance training program, which is through Department of Justice or state, geared towards teaching concepts that just make our embassies safer and make our citizens safer in countries that might have a potential for enhanced risk for terrorism. Yes, sir.
Okay. Have you made presentations and worked with the United States Army, the United States Air Force, the New York City Police Department, and police departments in California, Wisconsin, Oregon, Utah, Colorado, Illinois, among other places?
Been here a lot of times.
You are an instructor for tasers, are you not?
And not for Taser. I've never worked for the company.
Well, how does that work when you say you didn't ever work for the company? Tell us how one becomes an instructor on tasers.
So Taser was invented in 1965. A man named Jack Cover. And it went through a number of different patents and owners, but ultimately the Smith brothers, Rick and Tom Smith, took over the Taser patents in the mid-90s, slightly varied to get around some technical issues, but in the mid-90s, the Smith brothers created the current process that became the Taser today. And in 1999, they did their first instructor-trainer program where they would create training to teach teachers. And that first program was done in my police department by Rick Smith, the owner of the company. And I was in that class. And I always felt like that I had been training for a number of years up to that point, that if you ended up appearing to be in bed with a company, if you worked for a company, that your ability to speak truthfully without people wondering what your motivation was would be an issue. So I just made a decision in the mid-90s to, though I was very involved in technical training, whether it was pepper spray, whether it was a plastic bullet, tear gas, I would never work for a company because I just felt like you kind of have to carry the party line. And so Mr. Smith allowed me to go through that class with the understanding that I would not be a Taser instructor. In the early 2000s, there was a lot of controversy with police departments being accused of being too tightly aligned with manufacturers, getting free things, basically using tools on citizens in scenarios that might be questionable. And so you began to have training crop up where individual agencies wanted teaching from outside of a company. They basically didn't want the party line. And so the International Association of Chiefs of Police, who I've been involved with for years, largest and oldest police organization in the world since 1897, had me develop a Taser program. We actually couldn't use the term. It was Conducted Energy Weapon, CEW training program, to where we could teach agencies Taser process, but not be under the Taser banner.
And you have taught Taser courses?
Many.
Okay, you're familiar with the protocols for the current Taser, Taser 7?
Both the teaching and then what we would call your best practices policies that are out there. There's different groups that give models, examples of how they think the device should be used. Not all in lockstep, but I'm very familiar with those as well.
Well, we're almost done with your qualifications, but I want to ask you just a couple more questions. Have you had any academic affiliations where you're taught policing and criminal justice matters at a college level?
Yes, sir. I've taught seated classes at different universities. I mean, 3-day-a-week classes, and then I've done just adjunct faculty, things like that. I don't do anything like that now, and I don't anticipate it again.
How many officers over the course of your 43 years do you estimate that you've trained in the reasonable use of force, including tasers and guns? Give a sense of how many people you've trained.
It'd be thousands. I don't want to just guess. It would be thousands.
Have you received any awards during the course of your career?
Some, yes, sir.
Well, are you a member of the American Police Hall of Fame, for example?
Yes, sir.
And what is that?
It's just a national police organization that recognizes certain acts in police service.
Are you the recipient of the Silver Star for Bravery?
Yes, sir.
What is that?
It's an award given for actions that meet their standards to acknowledge, I guess, above and beyond the normal duty.
And what did you get the award for?
Rescuing a hostage in a liquor store holdup that had been shot, and engaging the suspect in that case and shooting and killing him.
Have you had any publications during the course of your career?
Around 100 articles, chapters for books, peer-reviewed articles, some not, but I would estimate around 100.
Mr. Imes, I could spend quite a bit more time with your qualifications, but is the history of your career set forth in your CV, which is Exhibit 1001?
Yes, sir.
We offer 1001 for the defense.
Is there any objection?
We do, Your Honor. It's hearsay.
It's his resume, correct? The objection is overruled and the exhibit will be admitted.
Did I contact you or the defense contact you for the purposes of your initial review of this case?
I don't remember.
Well, you were contacted. It doesn't matter who, but
Yes,
you were
sir.
contacted
I don't
to see if
recall.
you would review this case, were you not?
Yes, sir.
Okay, all right. How many cases have you reviewed for reasonable use of force, excessive force, that sort of thing in the course of your career?
A fair number would be between 2,000 and 3,000.
How many criminal cases do you have right now under your review?
4.
Of the 4 cases that you have, how many of those are you testifying for or on behalf of the police officer or against the police officer?
This is the only one that would be considered, if that's the perspective, for an officer. The other 3, my opinions, would be against the officer.
Are we paying you to be here?
No, sir.
And why is that?
I've decided in the mid-90s, when this process began, I began asked to review cases that I would never take a fee in a criminal case, regardless of the side that was calling me. I'm not Mr. Benevolent. I like to get paid like anyone else. But I just felt that something as significant as someone's freedom suggested I should give an opinion without any question about motivation. I may say things you don't agree with, but I don't think the issue of money coming into it should be a consideration. So I just decided in the 90s I would never take a fee for a criminal review of any kind, regardless of the initiation, but I've stood by that, and if I continue to do this, I'll continue to take that perspective.
Well, we asked you to review this case. Do you remember initially what you did review?
Yes, sir. It was a voluminous file. As I recall, our initial discussion focused around the deployment of a taser. That was the primary focus. This case, and in no way am I diminishing, it's not a complicated case, the facts itself, but the focus initially was the issue of a decision to deploy and manner of deployment of the taser.
Okay. So you looked at videos,
statements, various reports. I didn't review everything in it. I reviewed those things I felt were necessary to give me the information to render reasonable opinions concerning the decision to deploy and the manner of deployment of the taser. Yes, sir.
Which really centered on the officers on the scene, Mr. Wright's conduct and the
And then
training.
some foundational stuff, issues concerning what an officer would have been taught, what would have caused them to think certain things, but almost exclusively it's the officers on the scene. Yes, sir.
Now, since the trial began, have you reviewed actual testimony that the jury has heard?
In the last week, within some limits of my ability in the last week, I was able to follow some things that were online that involved testimony. Yes, sir.
Did you, for example, follow the testimony of Officer Lucky,
Yes, sir.
Sergeant Johnson,
Yes, sir.
Sergeant Peterson in training,
The training sergeant. Yes, sir.
and also Mr. Stoughton yesterday?
Yes, sir.
Well, let's start your review by your understanding of what happened here. Would you discuss the nature of the stop and what you saw, and then I'll get you some more specific questions on the use of the taser. What did you initially see in your review?
Yes, sir. You've got an officer in field training and a recruit, for lack of a better term, and there's an initial assessment of the vehicle in front that has something hanging from the mirror. Your state, as with other states, has a statute that says you can't have anything between the driver and the windshield. And so I think that was the initial reference. Field training is a process of work. You want recruits to do things and test them and figure out that they understand the basic practices and protocols. So the license was checked. There determined to be some difficulty with, I believe, the registration tabs. So you had basically your statutory issue about something hanging between your eyes and the windshield, and then a license violation, and the stop was initiated from there.
Okay. Was the matter of a warrant for a gun of significance to you in any way? The fact that the officer on the scene found out that there was a warrant outstanding for the driver of the car.
Oh, yes, sir.
Was that significant for you in any way?
Yes, sir.
And how so?
Police officers aren't clairvoyant. The best way to indicate what might happen tomorrow is what happened yesterday. So we teach officers to act on reasonable appearance. And so if I find a person on a stop that has a weapons charge or a gun warrant, it doesn't mean they have a gun. It means they very likely could have a gun because they've had one in the past. So an officer would immediately take a different perspective, not that they would act necessarily differently, but they would begin to address this call for service differently because we have reasonable, objective information that a gun could be in play.
How about the existence of a harassment order? Did that have any import in your evaluation of the case?
Same basic thought process. We teach officers to look at the totality of circumstance, everything involved in this case. So if we have, in this case, a female in the car, and we have a harassment reference as well, is that the person? What's the nature of the harassment? It just continues to elevate an officer's vigilance. And I want to be clear, it's not that we then use weapons or use force, but we absolutely look reasonably on appearance of the facts we learn as we move forward about potential danger, potential resistance, and then act accordingly.
Well, does the harassment order increase or decrease an officer's possible perception of dangerousness?
It would increase. I mean, it's certainly different than a felony assault, but it's also different than a shoplifting charge. So a harassment would indicate a personal interaction in a negative way, and it would just cause an officer to be more vigilant concerning that type of interaction.
How about the existence of the female passenger in the car? What significance was that to you?
The third party present, officers basically look at calls for service from a safety priority perspective, so that third citizen in there, not the focus of the event, increases your concern for her safety, but also what role, if any, she plays in that harassment charge. Is that the person named in that particular event? Have they made up? People do. It would be very relevant to continuing that investigation.
With a bench warrant outstanding for the driver, was there, in your view, an obligation to arrest him, meaning Mr. Wright?
Absolutely a mandate.
We have an opinion yesterday that the officers could have let him go because he could have been arrested later. And your response to that?
I'm going to object, Your Honor, as a misstatement of evidence.
The objection is overruled.
Police officers enforce the law. The order from a judge, in my experience, is literally the highest order we operate under. And if a court order, a warrant from a judge says that person is subject to arrest, they will be arrested, and there's consequences if you don't. Some states, including mine, criminalize it. If you don't serve an arrest warrant, it's a crime. Not every state, but that emphasizes the seriousness of it. It's not a request. It's not a suggestion. An arrest warrant is an order to arrest, and that's what police officers do.
So in your view, Lucky, former Officer Potter, and Johnson had to arrest him?
Dereliction of duty not to.
You know, as a supervisor, you know, in Missouri, one of the leaders of the department, would you have disciplined an officer for not executing or not arresting on a warrant from the court?
Beyond question.
Now, turning to the Lucky's behavior and his actions, you remember that he goes up to the car and asks Mr. Wright to step out. Is that correct?
Yes, sir.
Was that a correct police procedure in your view?
Yes, sir, it is.
Was it a correct police procedure in your view to tell him that he was, once out of the car, under arrest?
Beyond question.
And why is that important to tell someone like Mr. Wright that he's under arrest?
It may seem obvious that we would tell people they're under arrest, but in my experience, it quite often doesn't happen. An officer knows there's a warrant for you, and they stand the person up and say, turn around and put your hands behind your back. But it is a critical aspect of that officer-citizen encounter at the time of the arrest to look right at them and say, you are under arrest. And so in this case, we had two officers that actually said it. I just want to make it clear that the assumption that that always happens, it really doesn't. And so it's critical because it basically removes all confusion. When we say you're under arrest, that's exactly what that means, and you're required to comply with that order.
But what does Mr. Wright do instead of complying?
He initially just stood there and fidgeted a bit, and then there was the attempt to cuff him, and then he ultimately tried to get back in the vehicle.
In your 43 years, when someone wants to not be arrested and are about to be cuffed, what usually happens?
First handcuff's where it happens. When you take a hold of that first hand and are applying the first handcuff, in my experience, and that's taught universally, but it's like at that moment when they make the decision is when the hand goes on their hand, and that appeared to be what I saw in the video. It's the norm, but he began resisting at that point.
And what impact did that decision that Mr. Wright made have on the police officers at the scene?
The objection is overruled. You may answer.
It changes everything.
How so?
In policing, our primary focus is to react to what others do. There are certain areas we're proactive, but as in this scenario, we are reacting to what the arrested individual does as it relates to submitting to our lawful authority. If he complies, as almost every prisoner does, the handcuffs go on and the process works itself out. If they resist, then we will have to use that level of control to overcome the resistance and continue to work towards that lawful objective, which is effecting the arrest warrant.
Could the officers, in your view, just kind of let him go when he started to escape from the cuffing?
Objection asked and answered.
The objection is overruled. You may answer.
No, sir. Police officers are under authority. We're not military, but in many ways police officers are structurally in a system where they do what they're told, and they are told to serve arrest warrants. And now, is there room for variation? Do some agencies do other things? Sure. But the legal obligation to serve an arrest warrant is unquestionable, and if time he resists, their default is to overcome the resistance in a reasonable, safe way and get back to working on accomplishing that mission objective, which is to serve the arrest warrant.
Did you see from your review of the videotapes and the testimony that you've heard and watched that there were efforts after Mr. Wright initially refused to be cuffed to secure him?
Yes, there was an initial scuffle there at the driver's side. Yes, sir.
Was that a legitimate law enforcement technique?
Certainly. Grappling, soft empty hand control is the formal term, is the force used in about 90% of all resistance. I try to put a cuff on you, you begin to scuffle. I don't punch you, you don't punch me, we're just in a little bit of a grapple. And if I and my friends are able to overcome your resistance, the handcuffs go on, and that's that. Almost every time, that's what we do.
We've talked in the trial about control over a motor vehicle. Are you familiar with that phrase? Control?
I am.
Was at this point in time, or was this at this point in time, was Mr. Wright in control of his vehicle as he struggled to get back in it?
He was not.
Was he ever in control of the vehicle before the taser was shouted and a gunshot took off?
Not that I could tell from the video, no, sir.
What do you mean by control in police work?
Control literally means the ability to put it in drive and go. That's it. There's actually a Minnesota statute that references control in relation to DWI, and it talks about mechanisms of movement. That's not unique to Minnesota. Literally, control is just that. I'm in control, and I can go do what I want, which in this case was likely to go forward.
We've seen a lot of body cameras in this case, and then we've seen still shots of what happens. When an officer is in a situation like they were here, do they see in still shot framing what has happened?
No, sir.
Well, why is showing a still shot of what occurs different from what an officer sees?
The format for body cameras is called QuickTime Player. It's 29.5 frames per second. And you and I can just envision how well we could take a 1 second sliced 29.5 times and accurately or effectively see and assess that slice. So the slice is helpful in some cases, for example, to show whose hands are on a gear shift mechanism, but to suggest that anyone, officer or citizen, sees and perceives something you see in a 1/29.5 second frame is just completely unrealistic.
Well, compare what the body camera sees with what an officer sees when there is a struggle.
Sure. Officers, like all human beings, have varying processes physiologically, metabolically that apply to survival, stress, fear. And so, for example, you'd asked earlier, sir, about critical incidents. I've reviewed hundreds in which officers and citizens are talked with after a life and death scenario, and very common themes occur where vision is focused, very tunneled. Not always the same, but that's a very common theme, where loud sounds are silent or not heard, where a quiet sound is actually magnified. So the video records exactly what's happening without any of the processes human beings go through. In my experience in critical incidents, almost no one, officer or citizen, can ever accurately speak to what happened in all areas because their body just can't record, like a video, exactly what's going on.
I'm going to check that question and answer is beyond the scope of this expert's witness, expert's foundation.
Okay, no speaking objections. You may put your headset on.
And thank you all for joining us. We're getting into day 11. This is the first day of the defense's witnesses. So this guy, Stephen I. James, one thing that came up, people mentioned, and I found references online, he was involved in, testified in 2019 in the case of, in Pittsburgh, a 17-year-old Antoine Rose was shot in the back fleeing a felony car stop, and you know, that officer got let off, apparently. So so this guy's been, you know, testifying in all these different things like this clearly have also been around. International Association of Chiefs of Police and all those other kind of international police orgs. So, thank you for joining us. If you want to check out our website, unicornriot.ninja, just pull that up quick. Please share out our work if you can. We got the Kim Potter trial landing page right up there. We've got all kinds of different updates. Nico's been throwing some more updates in there as we go along. Thank you, Nico, for the help on that stuff. So we got the landing page right there, and our social media links are up there in the upper right as well as down on the footer. You can also sign up for our email list down on the footer as well, and that helps a lot. It's great to be able to reach people. We don't send out too many emails, but it is really helpful to be able to reach people by email. Thank you for that. And the donate link is up there on the top of the menu as well. So if you can donate to us, that really helps a lot. We're a nonprofit media group, and we do depend on your support. So thank you all for joining us. We're just going to try to keep sticking with this as much as capacity allows. We do really appreciate it. So they're out on sidebar. And earlier there was a lot of motions after the state officially rested its case. The defense was trying to get the case tossed on various things. There was sort of an argument. They want to try to demonize Daunte Wright's mother as well. So we're going back now.
The objection remains overruled.
As he got back in the car, Mr. Wright got back in the car and struggled. In your view, did he have control of that motor vehicle at that point in time?
He didn't, because he didn't leave.
The gears were not engaged.
Correct.
We've heard testimony yesterday about the differences of shooting into a car that's moving and shooting into a car that's stationary or in control.
Yes,
is that a distinction you make in your work?
It just depends on the circumstances. The key issue is balancing the need to use that extreme level of force with the potential consequences. He may need to do it if the vehicle's moving, if someone's about to die. And then you acknowledge there's potential consequences as it rolls. So it's not a black or white yes or no. It depends on the totality of the circumstances in each case.
You were asked to evaluate the decision to use a taser in this case, whether it was reasonable and appropriate. Is that correct?
Correct.
What is the standard that you're using to make that determination?
Quite often there's terms thrown around in American policing about standards, and to be candid, there are few actual standards as compared to other professions. By standard, I mean if you don't do it, there's action. There's something that follows. We have the Supreme Court, we have federal circuits, we have state statutes that provide standards that if you don't follow, there's consequences. But most of other policing is the result of organizational culture, training. There's 18,800 agencies in America that do many things to a degree of autonomy that is stunning to many people. So, from a standards perspective, what I prefer to teach is what I call contemporary police practices. And by that I mean it's what most people do. It's not that they have to do it. There's not a Supreme Court ruling or a statute. There's not a standard that they're in trouble if they don't. It's what most professional, smart police agencies do. And so to talk contemporary police practice, you have to look for where that body of knowledge would likely be. For me, and for most agencies, organizations like the International Association of Chiefs of Police, every chief in America is a member, been around since 1897. In 1987, they partnered with the Department of Justice to create the National Policy Center. And the National Policy Center was created to put together, their words at that time, models of policy on contemporary issues that agencies could use some help on. And so I've served on the National Policy Center board for over 20 years and authored many of their policies. So if you were a chief in the mid-90s when taser first became common, what do we do with this thing? How do we use it? Well, the manufacturer says this, and many smart chiefs would say, I appreciate that, but I'd like to talk to some people who worry about what I worry about, not selling devices. And so the IACP has a model policy on the use of the taser.
And what would that be?
Well, I wrote that policy. I created it for them, and it specifically speaks to basis or justification to use. And the general justification or basis is grounds to arrest or detain and a reasonable belief that physical force or resistance to that arrest will follow. That's not a mandate to use, but that's a general authorization.
Is that standard dependent on a proportionality of risk, or is there any concept like a proportionality? Sorry about that. In the standard that you've mentioned.
No, sir. The issue of proportionality and pulling in force is a very lofty, worthwhile goal. It's not a standard like objectively reasonable from the Supreme Court. To that degree, we want proportionality. We want to do things that are balanced and that make sense. But specifically, officers are instructed that their force has to be reasonable, which in some cases would not be the least amount of force possible. It may in fact be more than something else that you could have done, but that doesn't make it unreasonable.
So is the standard that we use for the reasonable use of force objective reasonableness?
That's the standard I've always been instructed on, yes, sir.
Okay. So you've reviewed the tasing in this case, the PowerPoints.
Yes, sir.
You're familiar with everything we've got here.
Yes, sir.
So let me answer the questions that you're here for.
Yes, sir.
Was the warning given by former Officer Potter, I'll tase you, reasonable?
Yes, sir. That's the standard warning. You just communicate in plain English.
It's a standard. That is what they're taught to do.
Yes, sir. I'll taser you. You just tell the person, and in many cases, someone submits. They'll raise their hands and say, I quit. That's the goal.
Was the warning taser reasonable under the circumstances in this case?
That is specifically taught in the lesson plan. Number of reasons for that. It's really not for the suspect. It's more for the officers and others around the event to understand that a taser is just about to be deployed.
We heard testimony yesterday that the taser in this case was, or the assumed use of the taser was too close to Mr. Wright to be effective in its impact. Do you agree or disagree with that?
That's completely untrue.
Well, tell us why Mr. Stoughton's opinion is completely untrue.
Two key reasons. The first is the Taser 7 specifically is designed to have a very wide arc with the close range deployed probe. The standard arc deploys about a foot every 7 feet. And one of their corrective measures with the 7 was to figure out that many police confrontations with suspects are at close range, and that degree of spread was insufficient to get neuromuscular incapacitation. So, number one, the 7 spreads wide at close range by design with the close cartridge. Independent of that, the physical positioning of a seated suspect changes everything.
How so?
Literally, as you or I sit here, if you envision a shot just below the chest or sternum area, which is a key aiming point for the upper probe, from that probe to the probe into a thigh is about 12 inches, which is marginal for neuromuscular incapacitation, as they say, as the crow flies. But on the body, it's about 36 inches. Because you stand, the electricity takes the path of least resistance. It doesn't go through the air. It follows the body. And to connect one probe to the other, it goes down the side, down the leg. And so a seated suspect changes everything as it relates to probe spread because their body's bent. And you end up hitting low and hitting high, not because you're at a distance, correct for that, but because of the angle of their body.
What would have happened had the taser, an actual taser, hit Mr. Wright vis-a-vis his ability to drive that car?
The actual taser device, when it performs as designed and intended, is the most effective incapacitation tool I've ever experienced, independent of a central nervous system disruption, and I apologize for being graphic, a gunshot in the head, something that basically turns off the lights. The taser is the second best thing out there when it performs as designed and intended. In actual operation, it's a relatively fragile system. Things can happen. Clothing can be lofty, a probe maybe won't stick. The very best studies out there, the most recent, January 2021 with LAPD, is all excuses aside, the taser actually accomplishes overcoming resistance about 67% of the time. So to answer your question, if it had performed as designed and intended, he would have had a neuromuscular incapacitation, which is a very significant physical lockup. In my experience, some people can do a little better than others, but most, it's not a matter of toughness. It's a matter of electronics, physiology. They're pretty much locked up. To get to a shift or a drive would be very, very unlikely in my experience.
And to drive thereafter would be unlikely too.
Objection made.
Well, I'll let you answer. The objection is overruled.
As long as continuity exists, as long as the trigger is pressed or the cycle is energized, and both probes have continuity, it will in theory do what it's supposed to do. But the second that breaks, whether they're driving away and the cord breaks, it pulls free, many suspects literally leap back into the game because it's electricity. And when it stops, now some people, oh gosh, that really hurt, and they kind of pause and seem stunned, but the idea that this is like pepper spray that carries after, it is either you're getting the electricity or you're not. And so the answer, sir, is if the cord broke, if it pulled free, in my experience, most human beings no longer have NMI because the electricity is simply not there, and their ability to recover and continue controlling their body would exponentially be pretty high.
Yesterday, we also heard an opinion that given the location, the close location of the officers at the scene, that shooting a taser would be inappropriate in light of where they were. Agree or disagree?
I disagree with that.
And why is that?
Police officers have to deal with the circumstances presented to them. And in actuality, we fight in close proximity with citizens, suspects all the time. And so you have to work around those as safely and practically as you can. And there is a risk. You can make a mistake. One of the very last arrests I made before I retired, I had a fellow officer spray me with pepper spray in a fight directly in the face on the ground. It can happen, but it's a balance between the need to use that tool, the potential benefit of the taser, with the risk of what would happen if you'd hit the wrong person. So we shoot close all the time. You can make a mistake, but it does not prevent you from doing what you need to do in most scenarios.
Was one of the considerations, at least in your review, of the potential danger that would result if Mr. Wright were not detained by the taser?
Just what comes with a fleeing suspect.
Tell us more about that.
No one has a crystal ball, again, to predict what a person would do, but the very nature of flight and resistance brings with it danger to people in the path of the runway. Theoretically, danger to a person in the vehicle if they are subject to that harassment warrant, which you don't know. Many unknowns. But again, the reason we serve arrest warrants is to put that process in front of a judge and stop it right there, because few good things follow when a person flees arrest and gets away.
And one of the dangers here, according to the testimony you heard, was the possibility of one of the officers being dragged.
I did learn of that last week, yes, sir.
And do you have experience with officers being dragged?
We recently retired this year an officer from my department who was permanently disabled, having been drugged in a very similar scenario, and was medically disabled. He's done.
Object, Your Honor. Relevance and notice.
I'll move on.
Yes, please.
Well, I object to that.
Well, I am going to advise the jury you should disregard that last statement.
In light of your review and the review of all the testimony that you've seen, was Officer Potter's perceived use of a taser consistent with contemporary and professional police training and practice?
Yes, sir.
And why?
The basic model policy definition of when the device would be used is completely relevant here. Grounds to arrest or detain, and a reasonable belief that physical force and resistance would follow. That was happening right before your eyes. And secondarily, when the physical control effort began and the dynamic nature of how he's trying to get away clearly needs to be stopped, just getting in the vehicle is significant, but officers would be aware of that weapons component and the concern, could there be a gun in the car? Could there be a gun on him? This isn't just about might this person drive away. So the need to stop it as quickly as possible is the key aspect. Nothing but the taser in that scenario had a likelihood of doing that without a risk of serious injury or death. The continued grapple, if you don't get that done and that car gets in drive, it's going to get bad. And the taser is that unique device that when performing as designed and intended would have put a stop to it, very, very likely in most cases.
Did you change your opinion as to whether her perceived use was consistent with the standards you described after watching the videos of Lucky and Johnson et al.?
No, sir.
What you didn't see in your initial review of the case was Johnson's testimony. Is that correct?
That's correct, sir. I saw that last week, I believe.
And he was the fellow who was reaching in to stop the car from getting into gear.
On the passenger side, yes, sir.
Was he at risk of great bodily harm or death if he had not gotten out of that car as quickly as he did?
Had the vehicle been put into drive, beyond question.
If, let me assume a hypothetical, if we have the facts as we have them here, and the officer sees Johnson in the car,
Yes,
sees him struggling in the car, and has a view of him, and further that the individual is about to drive away, or at least attempt to drive away with an officer who's in and out of the car, would that officer who sees him be reasonable in the use of deadly force in the face of Mr. Johnson's apparent risk of great bodily harm or death?
Object, Your Honor, as going for speculation and improper standard.
The objection is overruled. You may answer.
The question, sir, would be answered first by just understanding the basic decision-making process involving deadly force, and that is, can I reasonably articulate a belief that myself or another is in immediate danger of risk of death or great bodily harm? So if that's the standard, as an officer assessing the appropriateness of deadly force, an officer half in and half out of a vehicle that is about to be put into drive with the door open would certainly meet that standard of being in immediate danger of death or serious physical injury.
Okay. So an officer seeing that could shoot?
It would meet that standard, and an officer could shoot, yes, sir.
May I have a moment?
Yes.
Thank you very much. No further questions.
Thank you,
Right.
sir.
Members of the jury, we're going to take our morning break, okay? So it will be 20 minutes. Okay, you may step down.
Hey everyone, this is Dan at Unicorn Riot. Thank you all for joining us. So we've been watching the beginning of the defense witness process. Stephen I. James from Missouri, who was a SWAT officer and got an award from a National Police Hall of Fame for killing someone in a liquor store, part of his credentials. Anyway, we've been hearing from that guy. It sounds like the defense is done talking to him, so it seems like there'll be a cross-examination of him. So I'm just going to go run video from April 12th. There's a few interviews in there. We're sort of at the tail end of the action from that live stream. This was the night after Daunte Wright was killed. This was from the end of the next day following. So Kim Potter killed Wright on the 11th. This is more footage from the 12th. So thank you all for tuning in. We're just going to run that, kind of let that play through. We do really appreciate your support, all the chatters online, Facebook, YouTube. Thank you all for coming in. And Nico, thank you for helping help manage some other back-end things for me. I really appreciate your help. Again, this is Dan at Unicorn Riot. If you can support our work, Unicorn Riot's a 501c3 nonprofit media organization. Our website here is unicornriot.ninja. We've got a Kim Potter trial landing page. We got a donate link there up at the top. So thank you all for joining us. We really appreciate your support. And we'll come back as soon as court comes back in about 17 minutes.
Both the Brooklyns are next to each other. And here's the Brooklyn Park officers standing right here. Again, this is many hours past curfew now at this point.
Hey, they go Frank Nitty right there too.
Yeah, I saw. Yep.
Y'all got ninja police. I ain't seen no ninja police. This nigga look like the boss on Streets of Rage and shit at the end with this thing and shit.
All I know is that it's just so much easier to operate this camera when it's not upside down, and it's not upside down right now. Glorious day for me, or a glorious time at least, trying to maneuver the camera without the correct ability is very hard. So anyways, this is Nico from Unicorn Riot. Thank you, Chris, and anybody else on the back end helping out. You can probably check out our Twitter feed, _ninja, for more. We also are covering the Chauvin trial, so we have a long Twitter thread from the Chauvin trial proceedings today. And we also were out here last night documenting the police response to the community seeking... Yeah, you're feeling that? Seeking justice for Daunte Wright. Excuse me. So there's a lot of press here still, but a lot more officers at this point. People have still matriculated around this area. I'm not sure of what's happening in the surrounding areas, but the last few times when this types of police repression have occurred, people have taken to the corporate stores and taken goods.
Show the world we ain't got to do 50 on for y'all to beat us up, for y'all to pepper spray us. We ought to throw rubber bullets at us. Show the world how y'all really get down. Y'all know how this is. This end with y'all. Y'all got that corner. Y'all got that corner. Y'all got the front. This end with the police coming from the backside over there. Kevin us in, throwing shit at us, throwing smoke bombs, throwing tear gas while we peacefully assembling. Following all y'all rules. Every time y'all ask us to back up, we back up. Look, he got his gun ready. Relax your gun, bro. This ain't a video game. We people. You see how his gun relaxed?
Yeah. In real
You ready to pop something.
Yeah.
Why? We ain't even a
I
threat.
see that,
That's
yeah.
the problem. Y'all always ready to pop something when we ain't even a threat. See him with his gun, look. He chilling with his. Why you so amped up, bro? You ready. Why you so amped up? Relax your gun. Yeah, you. Relax your gun, bro. You ain't got to be mad because I told you. You ain't got to have an ego. The rest of your crew is relaxed. Relax your gun, bro. We ain't gonna do nothing to you. We just black people peacefully assembling. Finger on the trigger, you ready?
The crowd is growing on that side. I think something just got thrown to the officer. A bunch of people skirted away. Again, the crowd is growing to this spot because they pushed everybody out to this spot, and then they grew a little bit. And yeah, you hear the response. It's a water bottle. Why y'all tripping?
You get invaded Poland right now. You got all that shit on. Like, it make no fucking sense, bro. It's a water bottle. Y'all can't handle a fucking water bottle?
Right. Like, you don't see me throwing at your ugly face. Smirking about people.
I got my shit
What happened, bro? They said, stay back there. I'm not going back there to get my car. So we'll see. The captain told me I'll be able to get my car in a little bit, but this guy says we're not getting the car anytime soon. There's no going back across that line.
That's some bullshit.
What they said, they had to secure it, fortify it, or fortify it and secure it, and that'll take a couple hours, is my guess.
Yeah, I guess we'll see, bro.
Sorry, man.
My car's down there.
That was a reporter trying to get out, stuck inside. Like, the press has been finding it very hard to operate as press out here today. A lot of faulty information given to press detained for seconds out of spite, it seemed, when Louis Vuitton was detained. The police are continuing to have a large presence here on 69th Ave and Humboldt.
That mother ain't gonna be able to go to we don't make major moves. Met somebody, she already left me. Y'all gonna be mad. But guess what? Communities come together.
Oh, the Duffy's gonna take ass. They went for the next number of the game.
Hey, you'll know when that team goes they'll put their mask on. And now they don't have their mask on. They might shoot 40mm Mackinac. That's what they're doing right now. So just be aware when the people with the flashlights, if the people with the flashlights start sighting the flashlight at you, be aware. Yeah, be aware.
Yeah, drink that water, bitch, because you gonna need it. Drink the fucking water. Stay hydrated, bitches, because we not going nowhere. Stay hydrated, bitches, because we not going nowhere.
The reason why y'all scared of guns is y'all scared to come outside for real.
You bitches gonna need it. Put some on yourselves, too, because you gonna need it. I wish y'all had the capital this deep. Drink the water, bitch. You all you motherfuckers gonna need some water, so get to passing it out. We ain't going home.
We outside,
So again, thank you all for joining. This is Nico from Unicorn Riot. We're here live in Brooklyn Center at the second day of protests for Daunte Wright. Daunte Wright was killed by Brooklyn Center police yesterday around 2 p.m. not too far from the police station area where we are. It was on 63rd and Catherine area, 63rd and Lee area. It was a traffic stop. Supposedly, the police say he had a warrant, and the woman officer tried to take him, or they were trying to take him in, and a woman officer sort of pushed away another officer and ended up shooting him while saying that she has her taser out, she's going to tase him, she's going to tase him. And so that's where we're at with this. The police declared unlawful assembly here. They have a curfew going at 7 p.m. It's obviously way past 7 p.m. Central Time. Yesterday, at the scene of the murder, the police had 2 police cars that were smashed up, and then they took them out of there. And then they sort of left after they processed the scene, and then after the BCA processed the scene. And they only shot 3 marker rounds at people. We saw Cortez Rice a little earlier. He's out here. He got shot with 2 of them, I think, and another gentleman got shot in the ear. That was early on when the cars were getting smashed. Then people moved to the police precinct, and from what we witnessed at the police precinct was dozens and dozens, maybe hundreds of munitions being shot at the crowd, who was responding with water bottles and very minimal projectiles. There was some, other projectiles thrown, but nothing very serious from what I saw. And all those people, all the munitions that were shot by the police yesterday in front of the police precinct ended up stopping, or ended up just continuing until the police came in and swept the area with kettle type of tactics.
Black lives matter! 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 Y'all scared of us for nothing. For nothing. Why are y'all scared of the black community? I don't understand. Y'all supposed to serve and protect. Y'all haven't served or protect us, no generation. None of our grandparents, none of our great-grandparents. Y'all haven't protected us. We've been getting shot and killed. But this the wrong generation y'all do. But we gonna step.
This the wrong generation.
But we stepping.
You chose the wrong generation.
Hey, we stepping. Last one on my mom. We standing on that shit. We stepping. This the last one. We standing on that shit.
You bitches stink. Y'all look ugly. You dusty. You crusty. Go the fuck home. And you chose the wrong motherfucking one.
Y'all better, hey, in the wrong fucking city. They're fucking Brooklyn City. You ain't wrong city. You're not fighting for that. Wrong city. We're in the wrong city. Wrong town. Wrong people. We outside, man. We outside. We outside. We outside.
What's going on?
Y'all chose the wrong people. Y'all should have picked somebody else.
Y'all sticks up y'all ass. Y'all some
For real. Y'all better get comfortable standing. I hope your legs don't hurt. My soul. On my soul. Drop all that. Drop all that shit. On my mom.
I'm trying to get to a UFC fight. I don't give a fuck what your aim is. Any officer, nigga. UFC fight. Come out here right now. We whooping ass, cuz. No, cuz. We ain't gonna shoot y'all. Y'all ain't gonna shoot up. Hey, I just wanna say, fuck the police. We need them reparations. We out here doing all this extra shit, cuz. We get all these people together, cuz. His pants, what the fuck y'all owe us, alright? All this extra shit. We need reparations. We don't all that other shit, bro. They killing us. We'll get the fuck up out of here. There's plenty of countries that love black people here, okay? There's plenty of countries that love black people, alright? Alright, listen, we done did everything for this fucking country. We done literally years and years and years of ghillie wars. What the fuck else do y'all want? Do y'all know ghillie wars? Y'all look that up on y'all motherfucking TVs. 100 years of ghillie wars. Y'all want to reactivate that shit? Y'all want to fucking reactivate this shit because it can happen real quick and overnight. Anytime. You think it ain't for other countries that's willing to come here and help us with this shit? We facing a whole, it's an older demon that's been killing us forever. You motherfuckers done did this shit and your whole world did this shit. Y'all brought us here. Y'all brought us the fuck here. The fuck, if y'all don't want us here, give us what the fuck y'all owe us and we get the fuck on. And we don't want no cash, bitch. We want real stocks in this motherfucker. We want rice for cotton. We want the real shit. We want the rice for anything we get in this motherfucker. Oil, tobacco. I don't give a fuck what my ancestors did in this motherfucker. Pay us when we leave. Pay us and we'll leave. Y'all want us to leave? Pay us our fucking money and we'll leave. Right? All this shit, man, y'all want to kill us one-on-one. All this slave mentality, this shit dead, all right? Fuck that. So unless y'all want to see more genocide, more shit going on, come on, do what the fuck y'all, do what y'all know is right. Do what y'all know is right. Give us our bread, reparations. Give us our bread. Here.
Thank you, bro.
That's all we need, bro.
We gonna be in the road. I am getting closer.
Fuck you! Fuck you! Y'all can gas us now, but you'll see us again, and again, and again, forever always! Bitches! Drink some more water, you thirsty assholes! You're gonna need it! Your wives fucking stink, and you stink right with them dirty assholes!
Hey, clean your coochie!
I really hope your wife is fucking your homies, because y'all out here doing that shit! Y'all are
little dirty! Y'all little dirty!
Go the fuck home!
Hey, y'all gotta call more back or we not leaving. I'm staying tonight.
The largest gang in the city, right here. Y'all fucking pushed us back. The biggest gang. We get it. Curfew was at 7. I'm talking about a curfew. You made your point. Go home. Go home. It's past curfew. No justice, no peace. Prosecute the police. No justice, no peace.
Dude, at this point, I'm just vibing now.
Prosecute the police. No justice, no peace. Prosecute the police.
Keep moving forward. They can't stop all of us at once. We all lock our arms here. What's fucking? Come here.
Nigga got it back. Come on back. Fuck that shit, cause I ain't the one.
No justice, no peace. No justice, no peace. Wake up! No peace. That's how we do it right here. This is what community looks like. Yo, let's say yourself. I smell it. This is what community looks like. Over here, girl. Oh, we get further up.
People are coming all the way up to the police line. The song really got it for them. Expect some police interaction, some police movements. Looks like they're going to start arresting now. They got at least 2 people.
Let's say y'all ass on the sidewalk. Sidewalk. You sidewalk too. You sidewalk too, man. You sidewalk too, man. You sidewalk too. We've had multiple conversations. Yeah, we did have multiple conversations, yet you still talking to me though. Yeah, okay, so why are you over here? She needs to be on the north side of the sidewalk. Okay, so what is the north? That is due north. All right, so yes.
Well, you don't even know the difference between a taser and a gun.
Hey, hold on. Hey, excuse me, can you come back out here? You the main talk? Come here. Hey, can I chop it up with you? He the captain. Can I chop it up with you? He's the captain. Stay right there. We gonna stay right there. So if y'all serving and protecting, why the fuck is so many black people getting killed? Y'all still don't got an answer. Black people have been getting killed on national levels long before cameras came out. So why the fuck is this so much? Why is this such a big deal?
Free the boy!
Free everybody! Fuck
Free
off.
it! No!
Hey!
This arrest is taking a long time for them. That was one of the persons that got arrested.
She got a kid! And they're arresting her, dude! She's 17! You see that shit? Fucking got it! You're doing this because y'all fucked up! No, fuck you! Get the fuck out of here! What's up? What's up? Y'all think you're tough? I'm white, bitch! I'm out here!
Yelling and screaming out the pig! You didn't even work at Hornvale! Yelling and screaming out the pig! Contact the national lawyer!
I'm a pussy! Yeah!
Contact the national lawyer still! Stop yelling at the pig! Y'all don't even know who the fuck get arrested! Y'all don't even know y'all get arrested!
Hey, watch his ass.
Yeah.
Buddy ass on one. He definitely on one. The captain on some bullshit. Why you on some bullshit with the people, man? Why you on some bullshit with the people like we did something wrong, man? Y'all murdered somebody. We didn't do nothing wrong, man. Y'all on some bullshit. Then look at these motherfuckers. Look at SWAT. Look at SWAT right there. Look at SWAT right there. Look at SWAT. Look at SWAT right there. Look at SWAT right there. Alright, fuck off the road.
Still making the arrest right here. They just got the person up. Large amount of reinforcements have come, and they're probably going to start to kettle everybody from that side. Expect them to come along that side and start pushing everybody back this way.
Oh, yes, please.
All right, folks, we are back live. Stephen I. Jones should be a call for examination now.
Okay, you can come forward and take a seat. Okay, Deputy. Okay, please be seated. Mr. Frank, you may cross.
Thank you, Your Honor. Good morning yet, Mr. Himes.
Good morning, sir.
Thank you for being here. Talk to you a little bit about your CV.
Yes, sir.
Probably doesn't come as a surprise to you, right? You have been an expert witness before.
Yes, sir.
And if well, it's really seemed like you've really dedicated your life to law enforcement.
That's my only job I've ever had, yes, sir.
And really immersed yourself in it, right?
I'd say it's been more than just a career, yes, sir.
What has it been? More than a career, it's been a calling for you.
It has been.
Something you are completely dedicated to.
I am.
More than a 40-hour-a-week job?
For certain.
In fact, we know from, for instance, in your CV, your resume, there's a section where you talk about, I think the title is Operational Experience. You recall that section?
Yes, sir.
And you talk in there, I think that's about while you were working for the Springfield Police Department?
It may include some other times, but mostly SPD, yes, sir.
Okay. And there was, you talk in there a lot about the work you did during that time period and all of the different things you were able to do as a police officer while working in that capacity, correct?
Correct, yes, sir.
But even during that time, you were not just working for the Springfield Police Department, you were going out and doing other speeches, conferences, working in law enforcement for other agencies, consulting, correct?
For the U.S. government, yes, sir. For other entities, correct.
Yeah. In fact, during 2001 to 2007, which is the time when you were a major and a commander at the Springfield Police Department, right?
Yes, sir, I was.
During that time, with all those responsibilities, you also traveled really kind of all over the world to do other events for law enforcement agencies.
Yeah, yes, the city of Springfield, not unique to the city, but they decided in the early 90s to partner with the Department of State. We sent 27 officers to Haiti in '94 to assist in creating their national police force. So our department and city were committed to allowing us to participate in things that seemed to be in the interest of the government. So yes, sir, I had that support. If you hadn't had it, you couldn't have done it.
Thanks for offering that extra bit. I just simply asked you if you'd done a lot of that, correct? I didn't ask you about the other officers, right?
That's true, you didn't.
Okay, so what you did during that time period, for instance, 2001 to 2007, in 2001 you went to Canada to speak at a Chiefs of Police conference.
Probably more than one, but there may be one reference there if it was significant, yes, sir.
Okay. In March of 2002, you went to Asia to speak for the Department of Justice.
You said Asia?
Yep.
Okay, Indonesia? Is that what it says? I just don't recall the Asia. I mean, I don't think I would have been that general in my CV. It probably was Indonesia or East Timor.
East Timor.
East Timor. That sounds more like what I would have written, yes, sir.
And that is followed by the word Asia.
Okay.
No geography expert. I can't tell you where East Timor is.
Yeah, continent versus country, but yeah, thank you.
Okay. Okay. In 2002, you also went to Canada for the Chiefs of Police.
I'm sure I did, sir.
In 2002, you also went to England for a weapons conference.
Yes, sir.
In November and December of 2002, you went to Africa for the Department of Justice.
Correct.
In March and April of 2003, you were in Africa for the Department of Justice.
I agree.
In October of 2003, Scotland for a weapons conference.
Yes, sir.
November of 2003 in Jamaica for a conference from the Police Executive Research Forum.
Correct.
Law enforcement agency, correct?
It is like the IACP, but for bigger agencies, yes, sir.
England in 2004, February of 2004.
Correct.
In 2004, in June and August, you were in Greece for the Olympics.
I was.
And in March of 2005 in Yemen.
Correct.
June of 2005 back in Canada.
Agree.
July of 2005 back in Yemen.
Yes, sir.
May and June of 2006 in Uganda.
Correct.
June of 2006 Tanzania. October of 2006 England. October of 2006 Ireland.
Sounds correct.
Those are all for law enforcement purposes.
Exclusively, yes, sir.
And that was just what you did in those years while you were a commander at Springfield.
Correct.
Of all the entries that you told us about in your CV, you have, whether they were appointments or speeches, would you agree that the great majority of them are law enforcement groups?
I think they're exclusively law enforcement groups, sir.
Such as the National Tactical Officers Association?
Yes, sir.
International Chiefs of Police?
Yes, sir.
Department of Justice?
Yes, sir.
The Police Executive Research Forum?
Correct.
The Association of Chiefs of Police? Right?
Yes, sir.
The Armed Police Officers National Training Conference?
Yes, sir.
The Law Enforcement Television Network?
Yes, sir.
And that's just exactly what it sounds like.
It's a training process that gives televised training versus in-person for law enforcement. Yes, sir.
International Association of Law Enforcement Firearms Instructors?
Yes, sir.
The American Association of Law Enforcement Trainers?
Correct.
The Illinois Tactical Officers Association?
That would have been their annual conference, yes, sir. I would have taught at that.
I'm sorry, I didn't hear you.
At their annual yearly conference, yes, sir.
Institute for Law Enforcement Administration?
Yes, sir.
Let me just run through some of these, and I'll ask you a question then. The Indiana State Tactical Officers Association, the Ohio State Tactical Officers Association, the Massachusetts State Police, the FBI, Wisconsin State SWAT Association, the Oregon State Sheriff's Conference, the Utah State Sheriff's Conference, the Colorado State SWAT Association, and the LAPD.
Yes, sir.
All groups that you have done things for frequently.
Yes, sir.
And in fact, there's only a couple of things on your CV that are questionable whether law enforcement. You've done some things for the Convoy of Hope.
Sure. I think that might be under a different heading. But yes, sir. Worked for Convoy of Hope doing overseas relief stuff in Haiti and Nicaragua, places like that.
And even with that, you're still providing security and law enforcement function, correct?
It just depends. With Project Hope, no. That's exclusively leading teams at orphanages and things like that. With Convoy, I've done security assessments for them. But the majority of the work overseas in that context is a group called Project Hope, and that's not been security.
Okay. You did some things for the Penn State University Applied Research Lab a couple of times, right?
That's law enforcement, though. I mean, the Penn State Research Lab is less lethal weapons technology.
What you describe as your professional accomplishments are all from law enforcement groups.
Beyond question.
As Mr. Haney asked, the Hall of Fame for American police officers.
Yes, sir.
I'm sure that was quite fulfilling to be elected to the Hall of Fame, right?
Not in the context for what I got it, but understandable.
Okay. What could you mean by that?
It involved using deadly force against a person, and I didn't ask for that award.
Okay. Then, the Board of Directors of the National Tactical Officers Association.
Yes, sir.
Police Chief Magazine.
Is that reference to being on their policy, or I'm not sure when you say Police Chief Magazine. I've written for them, but I've also done editorial review for them, so I'm not sure what your statement there references, sir.
It's in your professional accomplishments section. So
okay.
Those are all law enforcement organizations.
Yes, sir.
Any writing that you have done has been for law enforcement trade magazines,
Exclusively, yes, sir.
including the International Association of Chiefs of Police. It's tough to say. The magazine for that group.
Yes, sir.
And the National Technical Officers Association's publications.
Correct.
So this is something you've really committed yourself to. You have also been retained before to offer expert opinions on law enforcement content.
Correct.
And I want to just clarify one point, if I could. You indicated on your direct testimony that you have 4 current cases, and this is the only one where you're testifying on behalf of an officer. Is that right?
I've got 4 current criminal cases under review. I probably have 20 civil cases, but only 4 that are criminal.
And this is the only one where you've been retained by an officer.
The other 3, either Attorney General or prosecutor would be, I don't know how to characterize it other than to say my testimony would not be supportive of the officer's use of force. That would be the best way to say it.
All right. So I really want to clarify that, because it's true you have been retained in this jurisdiction by another police officer on their behalf, correct?
From my perspective, this particular case from day one was to take a look at the issues, initially focusing on the taser, and just get my...
When you say this case, what are you talking about?
The case we're sitting in right now.
Okay. Well, I didn't ask you about that. You have been retained on behalf of an officer in another case in this jurisdiction, correct?
You mean, do I have another one right now?
Yes. You told the jurors you have 4 open criminal cases, right? You said this case...
I think I'm following you. I've actually got 5. I apologize if I think where you're leading to. I am involved in another case that I just realized that would be more supportive of the officer. So I actually have 5 right now. I've not done an expert report. I've not testified. I may be on the wrong case, but I do have another one I just thought of that I've not done anything on as far as a formal report or anything. So it would be 5.
And I'm not interested in having you talk about the name of that case or anything about that case, but I just want to make sure that it's being represented correctly to the jurors. Okay?
Right. I would have a second case in this jurisdiction that would be, as you're characterizing it, in support of an officer. That's true. I would guess I was trying to focus on those I'd either done reports on or done something formal on, but I currently am involved in a 5th case, so it would be a 2 to 3, not a 1 to 3.
You did a report in that case?
In this current case?
In the other case here?
Yes, sir, I have.
And a lengthy report?
Well, a report, yes, sir. I mean, longer than this one, yes, sir.
You have testified in court on a number of occasions as an expert witness.
Yes, sir.
These facts of being retained and having testified really not described in your CV, are they?
I couldn't hear the last part of what you said, sir.
They're not described in your CV, your resume, are they?
In my report?
In your resume, your CV, your curriculum vitae that Mr. Eng asked you about.
I don't understand the question, sir. I'm not hearing something, apparently.
I've been asking you questions about your CV, which is for the Latin term curriculum vitae.
Yes, sir.
I assume it's Latin. It's a fancy word for resume.
Yes, sir.
In that resume, you've listed a lot of your experience and your accomplishments and your awards and your trainings, right?
Yes, sir.
But you don't list in there how many times you've been retained as an expert.
I don't think in my CV, no, sir, at all.
And so you do not recall who sought you out or whether you approached the defense in this case or they approached you.
No, I don't think I approached anybody that I can recall ever that I can recall. I had a prior case with Mr. Eng, and I'm thinking the two overlapped. I just don't have a perfect recall of how we got together.
Okay. And you are doing this for free because somebody's liberty is at stake.
As I do in every criminal case, yes, sir.
And that's pretty important.
It is to me.
You indicated in your direct testimony you like to get paid, but you're doing this for free, correct?
I think like most people, you like to get paid for your labor, but some things are more important than money, so that's the decision I made, right or wrong, a long time ago.
You have indicated you have 43 years of experience in law enforcement, correct?
Continuous commission, yes, sir.
You have been doing at least 25 years of evaluating police officers' use of force.
I think that would be fair. It didn't really begin till I was a supervisor, so late 80s, yes, sir.
And you have testified as an expert, been retained to offer opinions?
Many times, yes, sir.
You are familiar with the constitutional cases on police use of force?
I am. I mean, I'm not an attorney, but I'm familiar from a police perspective, yes, sir.
And you try to teach those concepts to others?
From a police perspective, yes, sir. Not a legal perspective, but a police perspective.
And you indicate you have worked on several thousand police use of force cases over the past 25 years, right?
I think 2,000 to 3,000 would just be a fair estimate of applications of force involving law enforcement I've reviewed, yes, sir.
And in this case, this present case involving somebody's liberty, you were asked by the attorneys to review the materials and offer expert opinions concerning the police practices involved, right?
Yes, sir. Not all of them, but yes, police practices.
What were you asked to offer an opinion on?
As best I can recall, sir, the initial focus was on the taser itself. Of course, to use the taser, you have to have a lawful basis to have your feet where they were, so that involves stopping the vehicle, and then whether you would do things once you got there. But it was primarily focused on the stop and then the taser application.
And with all of that, you wrote a report, correct?
I did.
Your report is just over 2 pages long, is that right?
It's 2 or 3. Yes, sir, that's correct.
The opinions that you have, to me, seem to start about halfway down the second page.
I'll have to look. Yes, sir.
So the sum total of paragraphs in which you have opinions would really be 3. Is that right?
What was the number you said? I didn't hear it.
3.
Sure. That'd be about right.
You express your opinions as you have today on the stand in terms of contemporary police practices. Correct?
In response to questions concerning that, yes, sir.
None of your opinions today or in your report have utilized the phrase an objective officer in light of all the facts and circumstances known. An objectively reasonable officer in light of all the circumstances known at the time, correct?
I'm not certain, but that could be.
Well, I'm just saying, the way you have written your opinions, you did not use those terms.
Okay.
Is that true?
What term specifically, sir, am I looking for?
Whether a reasonable, an objectively reasonable officer in light of all the facts and circumstances known to the officer at the time.
I don't think I used those words in my written report, sir.
During your testimony today, you never used those terms to express your opinions, did you?
I don't recall.
Well, I recall, and I don't believe you ever used those terms for your opinions. The only time you used it was in reference to a Supreme Court case, correct?
I don't recall exactly what you're talking about, but I'm reasonably certain you're probably right.
In fact, when you were taking issue with the legal requirement?
I think there are cases that suggest that, but not to the standard of objectively reasonable behavior, which we have in Graham, which is the big focus.
And that was when you said objectively reasonable in referring to a Supreme Court case, which Graham is, correct?
It is, yes, sir.
Mr. Himes, do you have a copy of your report with you?
I do.
Did you actually write this report?
I did.
Okay. Did you write it for reviewing all of the materials?
I would have written it long before I reviewed anything last week. So I wrote it after I looked at the case.
Copy with you?
I do, yes, sir.
Your Honor, may I approach the witness to take a look at that? May I look at your copy?
Sure.
At the bottom of your report, below your signature, there are a few lines written there. One of the lines is, I need all of the records mentioned and easy access to the video, correct?
Correct.
So if you needed all access to the records, how did you write this report if you hadn't had them yet?
I don't even know what that is. I had Mr. Ng print this for me yesterday, so that would not have been on the report that I submitted back in September. I just I didn't bring a copy with me.
The report that was disclosed to us from Ms. Potter's counsel is exactly the same as the one you're looking at. It has nothing right on there.
I'm just not remembering what that was in reference to. I certainly need all the records mentioned, etc. I don't...
Well, why would that be on your report below your signature if you had reviewed all of the records before you wrote your report?
I would have reviewed everything sent to me up to September. I just have no recollection of what else might have been mentioned. To be candid, I don't understand what that suspended question mark, engine status question mark. I don't really know what that is. So I'm at a loss to tell you.
Yep, so it also says there's suspended question mark, correct?
Suspended with a question mark, yes, sir. I really don't know what that is.
All right. In your review of the case, are you concerned about or curious about something being suspended or someone?
I have no idea. Engine status, I mean, I really don't have any recollection of what that references to.
I do want to ask you about that one, engine status question mark, correct?
Yes, sir.
You told the jurors today that the whole issue of shooting occupants of a vehicle was not black and white, but it is a concern of shooting somebody who is operating a vehicle, right?
Or behind the seat in any capacity, yes, sir.
Okay. So whether the engine was on in that vehicle would be a pertinent consideration, wouldn't it?
It'd be one step closer to movement, yes, sir.
So the time you wrote your report, you were still questioning about the engine status?
I just don't remember what that means.
Did you ever find out if the engine was running?
I believe that it was, yes, sir. Keys in the ignition.
In your review of the body-worn camera videos, all Mr. Wright had to do was put it in gear to drive off, correct?
I'm not sure exactly how that vehicle works with brake and gear, but pretty close to that. That would be it.
Well, I think all vehicles require a foot on the brake to put it in gear, right?
I don't know.
Okay, fair enough. At the time of the shot, Mr. Wright's feet were on the driver's side floorboards, correct?
From my understanding of the video, yes, sir.
Now, it's your opinion here today that, and in fact when you wrote your report, that Ms. Potter only meant to use her taser, correct?
That's my understanding. I've not seen anything to suggest otherwise.
And one of the reasons you believe that is she only pulled the trigger once.
That's a factor. I mean, it's not a significant factor compared to other things, but that's a factor.
Well, probably the largest paragraph in your report is just about that very fact, that she only pulled the trigger once.
I'm just saying there's other factors such as verbalization and
Sure.
things like that that are more reflective.
Okay, but you told the jurors it's not a significant factor, but it took up a lot of space in your just over 2-page report.
May have required a few more words to explain that, yes, sir.
And what you're explaining there is officers are trained, if you're going to pull a trigger on a gun to use deadly force, you pull it multiple times, correct?
That's not necessarily true. It's just operationally they do. They rarely pull one time only. In some scenarios, they're taught to shoot more than once double tap. We don't teach to shoot in every case multiple times, but that's more common, of course, than just a single shot.
So when you were asked to provide a report for the attorneys who had retained you in this matter, you pointed out here that the number of times she pulled the trigger was a factor to consider, right?
Yes, sir, that's correct.
And what you said, what you wrote is, police firearms training nationwide generally involves rapidly pulling the trigger multiple times, and discharging rounds is necessary to stop a suspect's threatening behavior.
Generally, as I said, yes, sir. Not in every case, but generally.
Right. Taser training, in contrast, involves a single pull of trigger.
Press and release, yes, sir.
So that was a fact that you put right up front in your report in your analysis of your
Yes, sir.
conclusions. And, I mean, as you sit here today, as an expert, you agree that an officer's use of force is evaluated by the reasonable officer standard.
That's a segment of it, yes, sir, in the Graham case, the reasonable officer standard, correct.
But really for you, it's police practices and training. That's been the focus of your entire career, is training police officers.
Well, the reasonable officer standard is not some magical component of a police officer. It is the fruit of their training, their organizational culture, policy. They just don't raise their hand and get commissioned and become reasonable. We teach them. We try to prepare that. So,
but your perspective, your entire career has been devoted to training officers in their practices and conduct.
To be reasonable, yes, sir.
All right. So you must agree then, by pointing out the number of trigger pulls, that an officer's actual conduct can indicate what a reasonable officer knew at the time.
It would be one indicator, not necessarily everything, but certainly.
So you would have to agree then that because Ms. Potter only pulled the trigger one time, as with a taser, there's no reason to believe that a reasonable officer in her position at the time believed that shooting her gun was a necessary use of force.
I think I understand you're asking whether at the moment she fired that. I don't think I should try to interpret that. Could you just say it again, please?
Sure. You would agree that because, I mean, you pointed out the number of trigger pulls.
I did.
And you did that to support your opinion that she did not mean to shoot her firearm, she meant to use her taser.
It indicated less likely, yes, sir.
And indicated the use of less lethal force.
Correct, yes, sir.
And so you would have to agree then, since you're relying on it, that because she only pulled the trigger, she did not, a reasonable officer in her position would not have perceived a reasonable basis to shoot their gun, to use lethal force.
Well, I guess I don't know. I've not read any testimony from her what her perspective was, but from what I've seen in the video, and the assessment would be that an officer in her position was not perceiving the need to use deadly force, and so the use of the taser would have been the appropriate tool, and that's what she was trying to do. But I've not heard directly from her, so I just don't know that.
You agree, I mean, it sounds like you're kind of saying that this Mr. Smith gave you the opportunity to be the first taser instructor? Is that what you were telling us today?
I was in the first class of the master instructors. There were about 20 of us in 1999.
And proper targeting is a very common topic taught in taser training, correct?
That's a topic that's common and important, yes, sir.
And you agree that good probe spread is important to a taser achieving neuromuscular incapacitation.
That's the primary factor, is probe spread.
It sounds like what you're saying is sort of in the same way as having to shoot somebody in the head to immediately stop them, correct?
It would be more likely than the body, yes, sir.
Okay. But a taser deployment is not always effective at achieving neuromuscular incapacitation.
The best studies are about 67% of the time. From a practical, no excuses, did it work, did it not, about 67%.
So that's a lengthy way of saying no, it's not always effective, right?
I couldn't hear you, sir.
That's a long way of saying no, it's not always effective.
I guess, sure.
And I think your testimony was when a person is sitting down, you might be able to achieve a good probe spread just because they're sitting.
Because of the bend in the body, yes, sir.
But if the taser is only a foot or two away and pointed at the area of the chest involving the heart, that's not really going to, that may not achieve good probe spread.
It just depends on how far the heart is from the thigh. I don't know, but it may or it may not. If they're sitting up high enough that it doesn't get to the thigh and split the belt line, then the answer would be no.
But if an officer is trying to achieve that total neuromuscular incapacitation immediately, that's an important consideration, isn't it?
It's the key consideration for the taser to work, yes, sir.
And you agree that one of the purposes of the taser verbal warning is to alert other officers.
It is.
And to let go of the suspect, subject, whatever term you want to use.
I can tell you from a training, do you want me to just answer yes or no or to explain stuff?
Go ahead, tell me.
From a training perspective, the answer could be yes or no. The warning is designed for a number of things. One significant factor is there's been a concern about officers perceiving the pop as a gunshot and somehow reacting inappropriately. So that's one issue. The second is to make sure you're generally out of the path of the probes. If the officer saying that is there and I'm between you and that suspect, I would want to move. Generally, keeping a hold of a suspect may in fact be valuable during a taser deployment. Taser specifically instructs controlling under power, which means handcuffing while they are energized. And so having a hold of them when they're hit, if it occurs safely, is really the best place for you to be, because then you then move to handcuffing and don't have to reach to re-engage. You just put them in cuffs while they're being energized.
But it wouldn't be unreasonable for an officer to let go of somebody who's about to be tased from a foot or two away.
It would not at all.
You testified a little bit about this distinction between operating and driving a motor vehicle, so I want to talk to you about that.
Okay.
You're familiar with, I guess, training or practice on shooting occupants of a motor vehicle?
I want to be responsive to your questions. I don't recall any specific training on shooting occupants of a motor vehicle ever in my career. We have training that involves concerns about that, but there's no block that says today we're going to do shooting occupants of a vehicle. So that's the best way I can answer that. I'm not familiar with that particular block instruction. I'm familiar with many blocks of instruction that include unintended secondary consequences, like a person in a tree who gets tased and they fall. So I am familiar with training that speaks to what might happen if you shoot a driver.
Okay, so let me back up a little bit. It sounds like you're still talking about tasers, correct?
No, either way, I just gave you an example of secondary consequences of the shot itself.
An officer has to consider secondary consequences, collateral injuries, correct?
Not just with a taser or a firearm, really with everything we do.
Exactly. The example you gave, tasing somebody in a tree, they may fall out of the tree.
Yes, sir.
And you have tried to explain to the jury today, I think, about tasing somebody who's operating a vehicle.
Yes, sir.
So, but this general notion about using force on an occupant of a vehicle, right?
Right.
Comes from the very common sense and understandable concern that if somebody's driving a vehicle and you do something to them, the vehicle could become an unguided hazard, could become dangerous to others.
No question about it.
So is there training that police officers get and you teach about the dangers of shooting or incapacitating people who are driving motor vehicles?
I'm not familiar with any block that is specific to that, but I'm familiar with many blocks that reference it.
All right, maybe we're splitting hairs. It is a concern, isn't it, that it could cause collateral injury?
Any application of force when a person's involved with a mechanical conveyance, for an example, raises with it the collateral concern of the conveyance itself. It's different than standing in the street if you're on a bicycle. So all training, force application, involves collateral concerns such as an accidental fall down and they hit their head. I've never had a block unique to that, but all, in my experience, involves that.
Does the average officer in the street know this?
You said, does the average officer on the street?
You talk about contemporary police practices and training, and this has been your career. Does the average officer know about this danger?
Which specific danger are you asking me, sir?
Well, let me just rephrase the question.
Okay.
Did you review Brooklet Center Police Department policy about shooting into motor vehicles?
I don't recall.
Right. So you're not familiar with the policy that Ms. Potter would have been subject to as a Brooklyn Center police officer?
I'm just saying I don't recall it, sir.
In that policy, it talks about discouraging, I'll be kind without my words, shooting at occupants of motor vehicles.
Okay.
Now, would you agree with me that the reason for that is the potential for collateral injury when you disable the person driving the motor vehicle?
I just have to have you hand me the policy and let me read it to get the context. I don't remember it, so I just can't tell you.
But that general concept, do you agree with the general concept that that's the concern, is the risk that causes?
The greater risk that comes to my mind in the question you're asking would be concern about people close by, not the person driving off. So in the absence of reading the policy that apparently expresses the concern you're saying, I'd be guessing to tell you what we're trying to communicate to her in that policy.
Your concern is about others, right?
I'm saying you're asking me if it's the vehicle driving off. I'm saying my primary concern would be if there's passengers, someone close by would be more of a concern than the person driving forward.
If a vehicle that's being driven, if the driver is shot, it's not going to make them a safe driver, is it?
No, sir.
So that's the danger presented, right? Not only are you shooting that person, but you're putting others at risk because you've got a vehicle that's moving that could harm somebody.
It would depend completely, sir, on the circumstance if we're in a downtown street compared to in the middle of a cornfield. So it depends on the circumstance which one of those would be a greater risk.
I think we're just arguing in circles here. Right?
I'm just trying to answer your question, sir.
And I think we're spending far too much time on this. But what I'm just simply asking you is that a concern for collateral injury if you incapacitate a person driving a motor vehicle?
If you ask it that way, the answer is certainly and quickly yes.
All right. We were kind of going in circles. So you draw the line then at a vehicle that's moving and a vehicle that's not moving.
Well, moving clearly is in a condition to go forward. If the vehicle's in park and the shot is effective, then the vehicle's very unlikely to go forward. So I would draw that distinction, yes, sir.
So if a vehicle has a person in the driver's seat and all they have to do is shift it into drive, that situation doesn't present the same dangers at that moment as the vehicle that's already moving?
It does not.
It doesn't present any dangers at all?
That's a different question. There's still danger. If they're immediately incapacitated and the vehicle's in park, it's going nowhere. If they're not, then it certainly presents a danger if they have the capability to put it in drive.
You expressed some familiarity with Minnesota law about being in control of a motor vehicle.
I'd read, actually, I was curious, and I actually searched the statute, and there was a reference to operating. And it talked about feet, positions, conveyances, just I don't have it verbatim, but it specifically talked about what operating was.
What statute was that?
I can't tell you from memory. I just went to Minnesota statutes and literally Googled the word operating, and it was a statute in reference, I believe it was either car crashes or intoxicated driving. They were just a reference to conveyances or parts of the motor vehicle that allowed its movement.
Could a person under Minnesota's DWI laws be charged with the DWI for sitting in the driver's seat with the keys in the ignition and their feet in the floorboards?
Calls for a legal conclusion.
The objection is sustained.
Well, you told the jurors that you read some statute. I think it might have been, well, was it the DWI statute?
I just don't recall. It was just a reference to operating, and I just mentioned that in the fact that Minnesota statute even talked about operating a vehicle, so that was the sum total of that.
All right. In your report, you used the term operating/driving, correct?
Yes, sir.
Then you went on to use, in the next sentence, operational /driving condition, correct?
Yes, sir.
If you're drawing the line only at a vehicle that's moving, why did you feel a need to, in your just over 2-page report, add the term operational to that? Why didn't you just say moving or driving?
I don't recall.
Well, could it be that you actually did realize a person who is in a position to drive a vehicle, just simply all they have to do is put it in drive, presents the same kind of concern an officer must consider when they're going to use force on that person?
That would not be true because it's not the same concern driving versus in a status ready to drive. It's not.
Not the same concern, but a concern.
I've not disputed that, sir. That is significantly concerning, but not the same.
And not a sufficient concern in this case when Mr. Wright is sitting in the driver's seat.
I'm having trouble hearing the question, sir.
Not a significant enough concern for you when Mr. Wright was sitting in the driver's seat with the engine running.
I don't understand the question.
All right.
What are you asking me?
I will ask you. If a subject is sitting in the driver's seat, their feet on the driver's side floor, hands by the steering wheel, the engine running, should an officer take those facts into consideration when deciding to deploy a taser on that individual?
Agree.
Isn't this particularly true if giving the verbal taser command could cause officers to let go of that individual?
It would certainly give that individual a little more time, yes, sir.
Now, it's your opinion that if Mr. Wright had been in a position to operate that vehicle, it was not unreasonable for Officer Potter to consider a taser deployment.
Agreed.
You used specifically the word consider.
Agreed.
It's your opinion, though, that Mr. Wright was not in a position to operate that vehicle.
It's not my opinion, sir. He could have and proved that he could drive the vehicle. He did it.
In your report, you state, in the immediate case, Mr. Wright was not operating or driving the vehicle when the taser attempt was appropriately initiated.
Correct.
So is it your opinion that he was not in a position to operate or drive that vehicle?
He was in a position to operate it. He wasn't operating it at the time. That's my opinion.
Now, again, you have all this law enforcement experience, 43 years, correct?
I do.
Several thousand police use of force cases over the past 25 years?
Correct.
Right. You have been retained as an expert in civil and criminal matters?
I have, sir.
And testified? Right?
I have, sir.
You understood immediately upon being contacted about this case that an officer had shot and killed a man, correct?
I was aware of it, yes, sir.
And her attorneys asked you to offer an opinion regarding the police practices involved, correct?
With the primary focus on the taser. That was our discussion. But the police practices involved with a focus on the taser.
Did they limit you to just the taser question?
Objection.
With product, the objection is sustained.
Your Honor, may I be heard on that?
Yes.
Thanks for joining us. We're on day 11 of the Kim Potter trial. This is the first witness for the defense, Stephen I. James. And we've been finding a lot of stuff about what I. James has written, you know, talking about crowd control and less lethal munitions, things like that. So the man's definitely been out there and around and is a commentator on a number of these websites, including Corrections 1 by Lexapol. Lexapol came up earlier this week as well. So that's like now a parent company that owns Police 1 and a site similar to Police 1 called Corrections 1, which is aimed at, you know, law enforcement and prison guards and people like that. So, you know, he's definitely got his viewpoints out there in that world. We heard about Police Executive Research Forum. That was referenced. International Association of Chiefs of Police. I'll just mention in a little detail, Police Executive Research Forum, or PERF, ran conference calls that helped get Occupy shut down back in late 2011. All right, I thought she was going to start talking. Anyway, I'll hold the mic, but anyway, we will have some interesting stuff on the break. We do have some interesting stuff we found as well.
The objection remains sustained.
So with all of this experience and in your initial report, you did not at all address the use of deadly force.
I did not, sir.
Did you review Professor Stoughton's report before today?
I did, sir.
And when did you review that?
I don't recall. It would have been in the last month or so.
There was a discussion in that report about deadly force, correct?
There was, sir.
You still did not notify Ms. Potter's attorneys that you had some position on deadly force.
Objection privilege.
The objection is overruled.
I didn't feel compelled to go opinion for opinion with him. My opinions were focused primarily on the taser, and I read that, and I just didn't feel I had any compulsion to go back and say, he has this, I have that. It wasn't that kind of report. I wasn't in an argumentative process with him. So I just had to focus on the taser.
I'm sorry. So it wasn't until the testimony of Sergeant Johnson was pointed out to you that you suddenly had an opinion about deadly force?
When I was asked specifically about it, yes, sir, after I watched that testimony, that was it.
Okay. And so it was counsel that approached you about providing a deadly force opinion based on that testimony?
After the testimony last week, yes, sir.
excuse me, just a moment, please. And you met with counsel before testifying today, correct?
Last night he came to the hotel, yes, sir.
And you indicated that you then had an opinion about the use of deadly force, correct?
No, it's not last night. It was whenever the testimony occurred last week. I didn't see it live. I don't recall whether it was an email or a call, but he then said, hey, I want you to watch this testimony and give an opinion concerning the use of deadly force. The sergeant has introduced this. And, I mean, we talked about it last night, but that wasn't the first time.
All right. And is it true that all you said last night was, given Sergeant Johnson's testimony, deadly force was appropriate? Is that all you told them about your opinion?
Are you talking specifically last night in lieu of any other conversation?
Correct.
Objection privilege, what he told us.
All right. I'm going to let you go a little further.
Okay.
All right. You may answer. You may re-ask your question.
Is all you told them last night, given Sergeant Johnson's testimony, deadly force was appropriate?
I just don't really recall exactly. I think I would have said a lot more than that.
Your Honor, may I approach the witness?
Yes.
Ask you to review the last line of that, please.
Right. It looks like Mr. Ng writes, given Sergeant Johnson's testimony, deadly force was appropriate. I think he was taking notes during a couple-hour conversation. I can't speak for why he reduced it down to one sentence, but I said more than those words.
Now, Sergeant Johnson did not testify about a reasonable officer in Officer Potter's position, did he?
No, sir.
Okay. So the subtotal, and we have to assume, because I don't know what happened in that couple-hour conversation, it sounds like what you're saying today is that based on Sergeant Johnson's description of where he was at the time, that's what allowed you to then now formulate this opinion about deadly force, correct?
It wasn't just that, but that was a part of it.
Even at, well, when you were asked to do the review you did, you had full access to Sergeant Johnson's body-worn camera.
I did, yes, sir.
And you had access to the dash camera from Officer Lucky's squad car.
I did, sir.
And you had access to Officer Potter's body camera.
Correct.
And Officer Lucky's body camera.
Correct.
And you also had the written reports from those, from Lucky and Johnson.
I did, sir.
And the opinion you formed after reviewing that, based on your training and experience, was that Sergeant Johnson was leaning into the car from the passenger side.
Correct.
And today, Mr. Ng asked you to agree that Sergeant Johnson was half in and half out of the car.
I don't recall him asking me to agree to that. I mean, I've seen the sergeant's testimony. I can't tell you exactly where he was. He was probably more out than in, but he didn't ask me to agree to that.
And so this fact that you claim from Sergeant Johnson's testimony, that was the first time you thought deadly force was appropriate?
Which fact are you saying I'm claiming?
Well, when Sergeant Johnson testified about his position.
Correct.
And that only happened here during trial. It never occurred to you before trial.
I didn't assess this from a deadly force perspective in Sergeant Johnson. As I've said, I looked at this case initially and almost exclusively from the key factor from my perspective in my initial assessment, which was the issue of taser, a decision to use, and manner of use. I wasn't looking at it from a deadly force perspective, and so I wasn't trying to opine on every facet of this entire case. The crux of the case is the issue of the taser. And that changed when I was asked. I didn't just decide to do it. I was asked, based on apparently testimony that Sergeant Johnson did, to look at that particular issue, and then I did it.
Your Honor, I would like to show the witness exhibit 63. This is the body camera from Officer Johnson. And I would ask that we put that or go to the moment at 2:01:59.
Permission granted.
You can put it on. I don't know if we need to fire up the thing here. At this time, you would agree that this is the time, from your review, that this is the time when Officer Potter is saying she will tase him. You would agree here that Sergeant Johnson has his hands on Mr. Wright's right arm, correct?
Yes, sir.
And this was part of Sergeant Johnson's testimony the other day, correct?
It was.
This exhibit was shown and he narrated what was going on here? You saw that happening?
I recall that, yes, sir.
Then if we can run this for another second, please. You agree that at 2:02:00 here, we can hear Officer Potter saying taser, one of the three commands taser in the background, correct?
I think so.
And here we see Sergeant Johnson's feet on the ground and his hands holding Mr. Wright's hand.
Yes, sir.
Over to the right side of the passenger side of the car.
Correct.
Clearly not half in or half out, is he? Sergeant Johnson, I mean.
Well, I don't know how you would classify exactly half, but as I think I just testified to, probably more out than in is what I said a moment ago. All right, so bear with me, please. You testified on direct that when there is a warrant, an officer has to make an arrest. That may vary by state statute, but in my opinion, yes, sir, that's an order from the court.
Well, you told us about a Missouri statute, right?
I did reference my state. I'm just saying it may vary some by state, but I think that is an order from the court, yes, sir.
I'm not disputing you that a warrant authorizes an arrest. I'm not disputing that at all. But you said it was a mandate.
It is in my opinion, yes, sir. I don't see anywhere on there as a suggestion it says an officer is to arrest.
And, but in making that arrest, officers still have to use reasonable force, correct?
Certainly.
Can't just shoot somebody because they decide not to cooperate with being arrested.
I didn't hear the question.
If an officer is trying to arrest somebody on a warrant and the person pulls away, the officer can't just shoot him.
Of course not.
You were asked about how many critical incidents in your career you identified. You tried to define that term. Basically, it's a very risky situation for police officers.
I think that's fair, sir.
And others probably as well, right?
In many cases, yes, sir.
And you've been in a lot of those situations.
I have been.
And you've been with other officers involved in those situations.
I have been.
And those are life-threatening situations for you and other officers.
Many are.
Officers were there to help you in those incidents, correct?
They were.
You testified on direct that you got some material, but you didn't review all of it before writing your report. Is that what you
Correct.
Just decided what you'd seen enough, or how did you decide what to review and what to not review?
The file had voluminous medical information, which was not relevant at all to my opinions. Not that I decide I have enough. I just try to commit time and energy to things that make sense for my opinion.
Yeah. And so then you also testified that a warrant for a gun violation could make an officer more alert about potential danger, correct?
It should for certain, yes, sir.
Certainly. Don't dispute that with you, but could that include something like when approaching that person, unsnapping your firearm holster to make it more accessible to you quickly?
It may for some officers based on their training and experience. For most, the answer is no, but it may.
And that warrant, you're saying, is just one thing for an officer to take into consideration, right?
Yes, sir, just one of many.
Still have to use reasonable force in making that arrest, correct?
Yes, sir.
An officer in making that arrest could also be derelict in duty if they use unreasonable force.
Yes, sir.
You testified about, I think the terms you used were initial scuffle. Do you recall using those terms?
Yes, sir.
But it's true that nowhere in the body cam videos does it appear that Mr. Wright has assaulted any of the officers.
I didn't say he assaulted anyone, sir. I said there was a physical scuffle and he got back in the vehicle. He struggled to control.
My question for you was, did you see in anywhere in the body camera videos that Mr. Wright assaulted any of the officers at the scene?
Okay, I didn't hear that question presented that way. The answer is no.
You talked about body cam videos and the perspective of those, and you said that a slice is helpful to show whose hand is on something, but right, you said that a slice of that video would be helpful to show whose hand is on the shift knob, for instance, right?
That's one example of where a freeze frame is helpful, yes, sir.
But it may not be what an officer would perceive.
Correct.
Or have difficulty perceiving.
Beyond question.
But the officer whose hand it is would already know their hand is on the shift knob.
Independent of the video, they would know that, yes, sir.
That officer, if they are preventing that shift knob from moving, would know that that vehicle can't be moved.
At that moment, if they're effective, yes, sir.
told the jury that the model taser policy is one that you wrote up, correct?
I authored the 2007 iteration up to about 2018 for IACP, yes, sir.
And did you review Brooklyn Center's taser policy for this
I did.
case? It's not your policy. It's not the one you wrote.
No, it's not the IACP model policy. It's their own policy.
So the standards that you applied for your definition, there were two of them, are not in the Brooklyn Center policy, correct?
They're not that exact policy, correct.
And in fact, what the Brooklyn Center taser policy is that Ms. Potter acknowledged receiving and was trained on every year, right? You know that, right?
Yes, sir.
Certified every year. She had to be, she had to go over the policy as part of that training. You saw that in the records.
Yes, sir.
And that taser policy plainly says that the taser can be used when the subject is violent or is physically resistant.
Correct.
Where the subject has demonstrated by words or action an intention to be violent or physically resist and presents potential harm to officers, him or herself or others.
That's the language I recall, sir.
Different than the policy you wrote out.
It has different language, and most agencies are more restrictive or add more information than a national policy. Yes, sir.
And you would agree that it is more restrictive in the use of a taser than your policy?
Than the national best practices policy, yes, sir.
Why is it the national best practices policy? Why do you call it that?
Because it's from the International Association of Chiefs of Police National Policy Center, created by the largest professional police organization in America that every chief's a member of, in partnership with the U.S. government.
And which you have been a member of for how long?
I've been a member of the organization since probably the mid-'80s and served on that policy board for probably 20 years in one capacity or another.
You took issue with Professor Stoughton's explanation about probe spread, right?
I just disagreed with it.
I'm sorry, I didn't hear you.
I just disagreed with it based on what I know about how tasers work.
Okay. You talked about the Taser 7. And it's has a, well, it's true that the Taser 7 you can order with close quarters cartridges.
You can if you choose to.
And you were telling the jurors that this Taser 7 now has a close quarters cartridge that makes it more effective close up.
It spreads further if you have that cartridge, yes, sir.
But at, of course, 1 to 2 feet, still not going to spread much, is it?
I think it's a 12-degree arc compared to the standard 3.5-degree arc.
Did you investigate at all whether the Brooklyn Center Police Department and the Taser 7 that Ms. Potter was using had a close quarters cartridge?
I did not.
And I'm sorry, a little bit out of order, but we were talking earlier about the testimony of Sergeant Johnson. It was suddenly very important to you during the trial, caused you to have this new opinion about deadly force, correct?
No, sir. I was directed to look at it and asked to consider that. It didn't cause me to do anything different.
All right. Have you, well, let me say it this way. You have not in any way tried to assess whether a reasonable officer in Officer Potter's position would have been aware of Sergeant Johnson's position at the time she fired her handgun into Mr. Wright?
I have not.
Your Honor, may I have just a moment, please?
Yes.
That's all I have, Your Honor. Thank you.
Okay. Mr. Amy, you may proceed with redirect.
At the conclusion of your direct testimony, I gave you a hypothetical where the individual in a case like this actually sees Sergeant Johnson inside the car.
Yes, sir.
Does that change your opinion as to whether or not deadly force could have been used by that individual?
My understanding in our discussion last night and today, I was just caught off guard by reading what was handed to me, was that was what we talked about as a hypothetical.
Right.
If it's assumed an officer in this position was aware of that set of circumstances, and that was the basis for my opinion. Yes,
The
sir.
opinion was that
If that officer perceived that that fellow officer was in immediate deadly jeopardy of being drugged, then the answer would be correct. Deadly force would be justified.
and that would be in accordance with the objective, reasonable officer standard that we've talked about earlier today.
In my opinion, it would be, yes.
What would have happened to Sergeant Johnson or Sergeant Lucky if Mr. Wright had put his car in reverse?
Objection, Your Honor. Scope. Speculation.
The objection is sustained.
And we met last night at the hotel where you were staying, is that correct?
Yes, sir, we
And I
did.
asked you to review Mr. Stoughton's testimony too, is that correct?
Yes, sir.
And we've gone over what the areas were that you disagreed with today, is that correct?
I believe we did, sir.
The word retained was used a couple times for you. You were not retained in this case, is that correct?
Not by my definition of retention, no, sir.
Is it a violent felony to flee a police officer by accelerating a car away from them with a passenger in it?
No objection?
Objection. Scope.
The objection is sustained.
No further questions.
Any recross?
Just want to make sure I understand what you're saying. What was discussed last night, as well as not included in that memo, that email I showed you, correct?
That 7 or 8 words reduced down, apparently, that Mr. Ring said did not capture what was talked about in the entirety. No, sir.
But what you're saying here today, telling the juries, is if there was a hypothetical where the person knew that Sergeant Johnson was in the car.
That's exactly how I characterize it back to Mr. Ing. If it is assumed this set of facts, then my opinion would be that deadly force was justified.
So you're not offering an opinion about the actual facts of this case, you're just offering a hypothetical.
I don't know the actual facts in this case. I've not heard Officer Potter testify concerning that, so that's correct.
Have you examined other facts in the case to determine that without regard to Officer Potter's testimony?
No, sir. I don't think I understand exactly what you're asking, but the answer is no.
So, for example, you used the number of triples to reach some conclusions about whether she meant to shoot a taser or a firearm.
It is. The objection is sustained. And it's been asked and answered as well.
So you are telling the jury here only that it's a hypothetical, force could have been used.
I didn't hear.
Oh, we lost the feed. Sorry, folks. Hold on.
not be consistent with my hypothetical, so I agree with you, sir.
And I get a battle of words. You said retained, that would be not your definition of the word retained. You have not accepted payment for your work, correct?
Correct.
And that's what you mean by, you wouldn't use the word retained because you're not paid?
Retention to me is contracts. When people give you a contract and say we're paying you to do this, this, and this, I get many of those in civil cases, but for me personally, retention is a retention letter and a contract, and that doesn't exist in this case.
But what you did here was at the direction of the defense, correct?
It wasn't at their direction. It was at a specific request to assess the facts in the case specifically about the taser, and I gave them the facts from my perspective, and that was that.
Sure, and what I meant by direction was simply they told you what they wanted you to address. But I'm not saying they told you what to say, but they told you what they wanted you to evaluate. I'm trying to define retained, Your Honor.
All right, I'll let you answer that question.
My best recollection is from the initial conversation. It concerned the focus of the case was the validity of the stop and the decision to use and manner of use of the taser. That was going to be the focus of my opinions.
That's the direction you took from them?
Yes, sir.
So whether they're paying you or not, you're doing that for them, you're providing that service for them?
Correct.
That's all I have, Your Honor.
Any redirect? Okay. All right. Members of the jury, I'm going to let you go to lunch, and we'll start up again at 1:30.
They're heading to lunch. We have something interesting for you. Hang on a second, folks. Some stuff about I. James.
Okay, you may step down. Thank you.
All right, hey everyone, this is Dan at Unicorn Riot. Thank you so much for tuning in. We really appreciate your support, everyone out there on Facebook and YouTube. So we do have a little bit of interesting stuff about this defense witness, Stephen I. James, who has been testifying. There's been cross and redirect. Seems like I think he's done. So they're out till 1:30. But look, we will have a little bit of info for you. So take a look at this. He was also entered, one of our folks who points things out to us on Twitter pointed out that he was also entered as a witness for the Derek Chauvin trial. And so, okay, there's my mouse. Okay, so this file is hosted on mncourts.gov. You can look it up if you look for Stephen I. James and you search for his name and stuff. It will come up on Google if you search for him. Now, at the bottom, I'm not going to try to call too much attention to it, but there is, his contact address and phone number there is lesslethal@aol.com. I'm going to try to omit his phone number lesslethal@aol.com is given as his email address on this mncourts.gov document. Now, what someone pointed out to us is that there is a forum, an internet forum for highly regulated weapons that are regulated under a certain firearms act that are not, they're sort of above the grade of normal weapons in the United States. And that forum has the particularly dubious name of Sturmgewehr.com, and that, or STG for short, that name was actually picked by Adolf Hitler for propaganda purposes. Those guns, the STG-44s, were later an inspiration for the AK-47. So this forum is used to traffic in or sort of trade parts for weapons that are kind of regulated in a special way by the ATF. So there's a user on there called OTO Ridge and has 16 posts registered December 16th to December, last post December 2020, about a year ago. And so if you look on there, that lesslethal@aol.com, as well as matching phone numbers are on there. So he has been on this forum in the last few years, trading in parts, talking about various components of, higher end regulated weapons. And so there's contact info is attached on there. He's been sort of selling parts and stuff like that. So that's interesting. And special thanks to the person who was keeping tabs on this guy. I think they may have figured this out because he was putting his email address on there. So that's a little bit of a surprise, but maybe not that much of a surprise, I guess. It is significant, I felt, that to bring up that, apart from the fact that this forum was specifically named after a gun that Hitler named for propaganda purposes in World War II, was used on the Eastern Front. This man or unless it happens to be someone pretending to be him, posting his same email address and phone number as the mncourts.gov document, which seems like a reach. It would seem that this user, OTO Ridge, has made 16 posts between December 2016 and December 2020. So that's interesting, in my opinion, and thank you to the person that had the eagle eye to point this out, because apparently he was, I guess, submitted as a possible defense witness in the George Floyd, Derek Chauvin trial earlier, which I think is when this first came to their attention. I'll just mention couple other little things. There's this story, Kaiser Health News with USA Today reporters. Mr. I. James is reported. This was July 24, 2020. So this man is, obviously heavily involved in police organizations. But this particular thing looked at how so-called, less lethal weapons killed someone in Boston in 2004, right? These things are listed in their materials as saying a lot of the time, like, you're supposed to only shoot at the ground and sort of bounce things off the ground at people, not fire at them at close range. So the police, especially last summer, were routinely violating the rules that the manufacturers say you're supposed to use. So they can cause a lot of injuries. And Mr. I. James is also quoted in here. They talk about the Scott Olson case. You can see a scan of Scott Olson's brain damage from this type of weaponry. And this goes over some of the less lethal projectiles causing serious injuries. We certainly know journalists lost their eyes in Minneapolis because of so-called less lethal projectiles like that. There are journalists with eye patches from this. And so this goes over some of these other histories. Boston Red Sox victory, a fan, college student, was killed in 2004 by a pepper irritant. Sorry about the content advisory here for these injuries. It is quite bleak. 2003 Miami, FTAA, another famous crackdown in the earlier era of globalization protests. 1999 WTO Seattle is sort of mentioned in that box. There's a Stephen I. James segment. Retired officer who developed programs for IACP, International Association of Chiefs of Police, blames boneheaded policemen and a training gap for the misuse of arms. I. James noted law enforcement instruction focused entirely on how to use less lethal force against individual suspects. I. James noted not on crowd control scenarios that only occur sporadically. And so when demonstrations morph into disturbances, less lethal devices are often dusted off and pressed into duty. And, it talks about the sponge rounds and so forth. And they're sort of saying, oh, what's the alternative? We're stuck with these things. The National Institute of Justice, which is a pretty serious government entity in this, has collected data about less lethal weapons safety as well. But Congress has shown little interest in regulating beanbags and rubber bullets. So once again, they don't. And so there is more stuff about the policy. Again, this ran in summer of 2020 as a review. Serious injuries. Sorry about the graphic imagery, folks. More about settlements and injuries. There's a lot of info in here talking about the George Floyd protests, Los Angeles use. I've been looking around lately, and I've found a lot of Inspector General reports from different cities about how they police these things. And so, this is a long feature. There's a lot of info in here about the injuries and all of that. And so there's more about that there. Again, this piece is on khn.org. Less lethal weapons, blind, maim, and kill, victims say enough is enough. We have mentioned again, and I think it is worth highlighting, that there is a FEMA Field Force Operations Doctrine. We found this document in a FOIA. We released it in November 2016. And so FEMA's Center for Domestic Preparedness, or CDP, has a very large guide that does standardize this stuff, that does involve crowd control. It does talk about anarchists. It does talk about arrest tactics, maneuvers, protester tactics, crowd dynamics of everyday citizens, professional protesters, and anarchists, psychological factors, armor, boots, the 40 millimeter launcher rounds. We saw a bunch of that in the footage we've been looking at from April 12th. Shotgun rounds, these hand-tossed munitions, defense technologies. A lot of the footage from Nico Brooklyn Center had defense technologies munitions. So we got that stuff in there. And so the full PDF is here. If you want to learn about Field Force Operations, it is 135 pages, but it will definitely give you a strong sense of the tactics that are used and standardized, which the Kaiser USA Today report did not talk about. So there is actually a separate federal doctrine that is installed in local police forces about mass crowd control, which is different than individual crowd control. So just wanted to mention that quickly. Someone's referring to a few things about Iran-Contra and various networks and stuff in the YouTube chat, and I will just say, stay tuned on that point. Again, just to circle back, so we found this OTO Ridge person making 16 posts, dropping the phone number and email address, which is the same as the phone number and email address in this mncourts.gov document. This man who's been on the stand has been trying to unload various regulated weapons in this forum, which is named after Sturmgewehr, a gun term specifically developed by Hitler, so you can kind of guess who that appeals to. It's been around since 1999. It's got a very, soldier of fortune aesthetic there. So just wanted to share that one because that's pretty unusual, and I just wanted to share that. So thank you all for so other people are saying that's confirmed elsewhere. So, I'll just kind of say okay, email, phone number, that's pretty significant, but, we haven't talked to this man. We don't have a confirmation from him admitting it, but, the data is definitely pretty strong right there. So thank you all for joining us. We're going to just sort of run another, let's say, half hour. We're going to run another little half hour, that tail end of the material from the 12th. Then we'll go down and sort of rest for a little bit, come back for the afternoon session. So we do really appreciate your support. Someone else is saying that this name and email address is popping up in other gun forums. So, if you crack out the Google, we can all sort of find out how many gun forums Mr. I. James has been on when he's not writing these articles for Police One or whatever. Anyway, thank you so much for the support. Again, Unicorn Riot's a 501c3 nonprofit media organization. You can find our work at unicornriot.ninja. We got the Kim Potter trial landing page. Thank you for Nico for updating that consistently. So there are updates on today. We have a new piece. I'll reload. We have a new piece about Jair Bolsonaro in Brazil. A commission found that he committed crimes against humanity. Our contributor, Emma Cheesthog from Brazil, submitted that. So, we've been trying to build out that global coverage, right? If you hit the global tag, you can see the category on our website. We've really built out, basically in the last year and a half, we've been trying to, get contributors from around the world to talk about different social issues that you're not hearing about through the regular U.S. media. And that's because of your support, because people have been donating to us this space of small donors, repeating donors. We have Patreon as well. So we do really appreciate that. We also have, the one about people making art projects, kind of messages for Daunte Wright's family. We heard from Daunte Wright's father at the end of the state's case yesterday, talking about, spark of life, that, he was now a grandfather. Daunte was a father of a young child, so we I've been trying to draw that context out there. We also got the Al Diddy case from our contributor, Sam Richards. Sam worked for years following this, right? Like, Al Diddy was someone who had an administrative subpoena to track down a whistleblower email that he sent after working his adult life as a union man in the Minneapolis, public works, sanitation, city servant. He got basically shoved out of the city, basically leak plugging, right? And so in this post 9/11 era, there's a lot of leak plugging that goes on. It's not seen as legitimate for city employees to talk with journalists about the issues that they face. And then KARE 11 forwarded that whistleblower email from an AOL address with all the header data to the Minneapolis Police Department, which then set off the administrative subpoena, and that was signed off by Jeff Rugel, who used to run the Strategic Information Center. I won't go too far into it, but the Strategic Information Center was also used, could still be used, to create sock puppet fake personas, in other words, fake accounts, to track protesters, to get email updates when protesters are doing things. So they do a lot of using these post 9/11 intelligence, whether it's fusion centers, strategic information centers, whatever you want to call it. They're doing a lot of tracking. And so this tracking down of this city employee, Al Diddy, was an example of the use of all these investigative techniques, because the police apparently have the kind of time on their hands to be tracing down employees who are talking to journalists instead of working on more serious security issues. So that was an important piece. Thank you, Sam, for working on that for years. There's also 2 of the radio pieces that he did, which are hour-long sort of podcast-style radio, community radio pieces in this story as well. So that is an important example of how, basically we see this pattern over and over, that people can't blow the whistle, they can't talk to journalists if they're in these orgs. The leak pluggers, the G. Gordon Liddy, Nixon plumber types will find them, track them down, use administrative subpoenas to crush leaks, basically. So as we've learned from Minneapolis, that didn't resolve the underlying social tensions in Minneapolis. More riots resulted, frankly, because the leadership in the city was more interested in doing things like plugging leaks than addressing long-standing social problems that lead to tension and riots. So I that's my personal analysis of it, that, tension builds up because they don't work on them. They'd rather, crush the leakers than work on the social problems. That's my personal take on it. Thank you. So I will hold it there. Thank you for that. I do appreciate everyone's support. Thank you, especially Nico, for diving in today. We do have some more interesting material coming up for you. We're just going to kind of keep cutting things loose as much as we can coming into the holidays. Thanks again, everyone, for the support. We really appreciate your, friendly chats today, helping everyone kind of figure out what's going on with this case. So we'll be playing this stuff for about half an hour, then we'll go down and come back for the afternoon session. Thank you, everyone. Again, I'm Dan, and I really glad to be with you all here today. Thank you.
Nigga, whites at home, husband at home. Y'all ain't ready to die for this shit. You done ready to die for this shit. You ain't ready to die for this shit. You're not ready to die. You got backup. Y'all got backup. You got tank. You ain't captured us. Take that shit off. Put it down.
Sorry. They just shot mark around at somebody. So these are the 2 people that were just arrested a minute ago. Dude, I'm filming them. Oh, 3 people, looks like. The police on their ultra transparency again. Cool, guys. Cool. Looks like they're allowing this person to walk by. This officer just handed another flashlight to his friend officer so he can shine it at the camera. He said, who, this guy, the media? So, interesting. The light games continue with the police. They do not like you to see them for some reason. So again, we're here live in Brooklyn Center. Everybody's out here for Daunte Wright. Daunte Wright was 20 years old when he was killed by Brooklyn Center police. This shooter is ready to go.
Alright, I'm gonna try to get out of here. I'm gonna try to walk around the block since everything's down here right now. They might have more cops down here.
Okay, oh look, you might be losing your opportunity.
See if I can get to my car or something.
Okay. Stay live the whole time.
Yep, I will.
The police are making their move right here. We sort of knew that was going to happen. So they made their line until that building, and now they're going to pull in and clear this area from this cordon of the kettle. So expect them to start moving in however long, and they'll start with the move. Expect that very shortly.
Hey, are we exempt or not?
Yeah, you're good. Yep. But they keep saying, you know, that you as press are not exempt from the unlawful assembly. So here goes the moves, very quick moves. That's like double time. You got an officer in the back smacking his baton on the ground. Now they're yelling at each other, stop. This guy right here is the captain, I think, of this squad.
Get back! Get that light off! Get those lights off!
We're media!
Get the fucking light off!
Okay, sir! Fuck out of here, man. Fuck. So a lot of people are leaving, but still there's people here in the parking lot.
County Sheriff Department.
You okay?
Let's see how far they can go. You don't know you can use. Fuck all y'all bastards. You cannot be upset because we are upset. Y'all have been killing us for years. Guys, back up, please. Please. Fuck you, terrorists. You back up. Fuck you. You back up, bitch. Fuck you. Go home. Hey, we gonna cross over that.
Hey, Louie. You happen to have a C cord?
A what?
C cord?
Unfortunately, I don't. Your phone dying?
It is, and somehow I only have a different cord. No problem. I'll ask somebody else.
Let me see. I have.
No worries. Keep doing your thing. the song back on. It was NWA, Fuck the Police, that sort of hyped people up to get out here like they are, move up towards the line. Some conversations happening now. So, see the police line go very deep, again down 69th Ave. Still a volatile, emotional time. The emotions are charged out here still. Daunte Wright was just killed yesterday. People are getting shot at by the police. People are getting arrested. Numerous people have been arrested. They might just be getting detained and then given a ticket. I'm not sure if they're going to be arresting everybody and like putting them in jail, but because I feel like I did see a few people off to the side that had got snatched up, and they might not be getting arrested. It's just a might not. I don't have anything to back that up, just besides my feeling of what I think I saw. I feel like if they were arresting them, they would have brought them into the police station or into a different area. The ones that they snatched up here, they were just sort of like processing them or talking to them on the corner, so I'm not sure.
Nico, right?
Yep. This is all Anoka County, I believe. I believe this is all Anoka County. Looks like the police are going to make a move very soon, is my guess, within a certain amount of time. That captain right there, he's got his arm up. Oh, he's got his arm up because he has his flashlight in it. The crowd is a few hundred still. I don't know. It's 100 or a few dozen. After the curfew. So the police are making moves. They're trying to do the kettle maneuver. Right now they're making the moves to kettle people. They just said grab that Explorer. What are you doing? I'm pressed. I'm pressed, dude. I'm pressed. I'm pressed. I'm moving out. I'm moving out right now. I'm pressed. Dude, I'm pressed. Stop. I'm pressed, man. I don't know what you're doing. I am pressed right now. Watch out, Mr. Conservation Officer. I can't see either. Move around, man. Move around, bro. I'm not doing nothing. I got you. I got you. I'll show you my credentials.
Just hold on, okay?
Okay.
Stop pulling.
Well, you came up to me trying to pull me. Here you go, sir.
You gotta get the light. I can't read with the light in my face. Thank you. Oh, you just dropped something. All right. You're good. But you understand when the lights are in my face and I can't see and everybody's trying to light your face. Shots. Oh, what the fuck?
So a bunch of shots were fired. And then a bunch of rocks were thrown. I don't know why that conservation officer was trying to arrest me. Get out of here, dude. More shots being fired in the air is my guess, but possibly towards the police. We heard a volley of shots, numerous volleys. They say get the TRV up here. I think those are just straight in the sky. It's just, we heard a lot of it during the George Floyd uprising. Police will make these moves on people, and then people will move around and shoot. Sometimes they were shooting at the police, sometimes, most of the time not. Again, it's not like people want to be out here. It's not like people are like, woohoo, fuck the police. No, the police keep killing people, and then people come out in response, and then the police come out in response. And wow, I feel bad for that residential person, if that's what they are. They're just driving by, like, what the heck. So they did arrest this person. I'm trying to film, man. Fucking dicks.
So at this point, what they're really doing is they're really worried about these vehicles that look like that pulled up from multiple vehicles and not the passengers removed. So they've removed the passengers and arrested a couple of them that we've seen. They've continued this push, and that's what's interesting because they did initially tell us that we'd be good if we stayed on that intersection. As you can see, they pushed past that barricade now, and they continue to push this way.
So yeah, we see the troopers making their moves now up the street. They got real live fire. We're gonna come to the side of them. But they got the live fire out, and they're walking down a residential parking lot. They're actually taking cover.
Get that light out of here. Turn the light off so we can see what we're doing, please.
Someone's phone.
Shit. Not me. No, not me. There's a phone that's been dropped. Man, ain't nobody scared.
So those are officers saying that they did also hear those gunshots we heard earlier.
Somebody missing a phone over here?
Somebody's phone?
Yep.
Shit. Keep it with you. Keep it with you.
Yeah, shit.
So at this point, what the
I literally just lost my phone over there too, and I ran back with a flashlight of somebody's phone, and I fucking found it, bro.
Whoa.
That was lucky as fuck.
Wow.
Right?
Yeah.
Fuck.
What's your name, bro?
Woody.
Woody?
Yeah,
Good to meet you, man. Nico.
I watched you yesterday, bro.
Appreciate it.
I was following you the whole time.
Good to meet you.
Good to meet you, bro.
People are doing sort of a sideshow right there off of 70th and Humboldt, letting the tires squeal. Police are moving down Humboldt. They're going to go into this vehicle now.
This is what we've seen a couple times now. They're asking everybody to leave the vehicle. It looks like maybe there's only one person in this one. We'll see if they let him go or if they arrest this person. Okay, they're getting the zip ties out. Looks like this person may actually be arrested. Nico, any word on where the shots came from?
No. Your ears, did you hear them? Yeah. Your ears are probably as good as mine on that one.
Vehicles to kind of form this line, and the officers are right behind.
Yeah, I do
the
not
vehicles that
know.
are pushing
Hard
up
to tell.
Right now.
I'm guessing, like, you know, right down there. So here's the 2 SWAT vehicles coming through as they try to clear the rest of this area. This man is from Wisconsin plates, and it looks like they might be press. They just got put back into the car so they can actually grab something or something. I'm not sure.
Any kind of slogans or march happening at this point. Really, people around me are there 95% correct. But the police are continuing to push down this way. He's gonna move.
They're gonna let this person go.
Okay, looks like they did let this gentleman leave.
So we got the neighborhood reporters behind us. They're on Instagram. Follow them.
This is Unicorn Riot.
Hey, bang, bang.
Shout out to Unicorn Riot.
Where do people find your work?
You can follow us on Instagram at the Neighborhood Reporter. That's where we're most active. Check out our stories. We're out here as much as we can be. We also have articles and infographics covering the trial of Derek Chauvin. Shout out to the Unicorn Riot for always showing love. Thanks, I appreciate you. Love you.
So yeah, you heard from neighborhood reporters. Then we got Louis Tran. We got quite a few other independent media out here. Chris June is over there. Quite a few other folks that I do not even know their names, but they're all important out here, being media, filming what's happening. They are the 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, about 20 media out here. I don't see any protesters left, maybe 2 protesters in this group of 20. And people have sort of left this area. And the police are continuing to clear, come down Humboldt. It's like the officers that were worried about the gunshots are not worried about it anymore. Oh, yo. Hello? Yep. Hold on 1 second. I'm gonna mute this.
Hey everyone, thanks for joining us. We're just watching kind of the tail end of footage from April 12th, 2021. This was the second night from the day after Daunte Wright got killed.
Sorry about that mute.
Potter. So we're going to have this up for a little bit, then we'll go down for lunch and come back
Actually,
on the stream.
Person that lost their phone, and it's not my job, but trying to make sure they get it back. So they had called. Perfect. Anyways, we're here live on Humboldt Ave. You see a large amount of police presence. State troopers, Anoka County sheriffs, and other sheriff's departments. and Minnesota conservation officers, and Brooklyn Park. I'm not sure if I saw any Brooklyn Center officers out here tonight, but those are some of the officers that we've seen. They're making their moves down Humboldt.
So, the mayor of Brooklyn Center and 2000 spoke on the other side.
Oh, really?
Yeah.
Tonight? Just a little bit ago?
Well, before I left.
You want to talk about it?
No.
Yeah, cool. What was the discussion about?
It was about kind of like calm down, do your thing, go home. Tomorrow's another day. And they wouldn't answer any questions from press. And I'm fine talking about it.
Yeah.
They wouldn't answer any questions from press. Keith Ellison seemed really angry at the idea of talking to someone from the media.
Oh, wow.
Someone asked on the other side if there'd be a separate private investigation beyond the DCA or the
Yeah.
So they were really dodgy and angry. The question of the
Transparency and accountability.
Yeah, there wasn't any of that.
Oh, that was the mayor and Keith Ellison?
The mayor of Brooklyn Center.
Yeah, so Mike Elliott and Keith Ellison? Wow. You captured it? You saw it?
Yeah, I recorded it.
Nice.
Let's see if I got it. Oh, yeah.
Officers are trying to tell the car that's driving up in the residential neighborhood again. It's a residential parking lot. The people's trying to go home probably, and they're told they cannot do that.
I can show you this though, if you want.
That's the thing that brings.
Oh, I think there's another clip.
Hold on one second. Hold on. Hello? Humboldt. Mm-hmm. Hold on one second. Hey. Yo, I got a homie's phone.
Yeah.
He left it on the ground.
Okay.
I'm trying to get it back in.
Okay.
I'm lashing him.
Where's he at?
He's trying to figure out how to get up here.
Who is this?
Could you yell for him?
Yep, I got you.
Yeah,
no
thank you,
problem.
bro.
No problem. No problem.
Thank you.
So here it is.
So yeah, here is Mike Elliott and Keith Ellison.
And then I got one of Keith speaking too.
So again, this is Mike Elliott, but that was Mike Elliott, Brooklyn Center Police, Mayor. Here's Keith Ellison, Attorney General.
Prosecuting criminal conduct, all right? And so I hope you know that I don't need to tell you that I'll prosecute the police because I am doing it now, like right now. So I'm just asking you all to understand that this thing is not going to be swept under the rug. We're going to deal with it in a real way. But I do not want any of you guys to be hurt. And if you go into that crowd, we don't know what will happen. You stay, wait a minute. Y'all stay at your distance and shout church, raise the issue. Speak loud. Do your don't nobody want to see you hurt. And we don't want to see nobody else hurt. For that, brother. Well, we don't want to see nobody else hurt, right? And so look, raise your voices, but let's do it in a way that everybody stays safe. We don't need no more casualties, no more martyrs. Certainly nobody here right now.
So again, this is Keith Ellison earlier tonight, just an hour or two ago, a little bit ago.
And I'm trying to get back to work on it so we can finish it up and get our conviction. But we don't want no more new cases. We don't need no more new cases. And certainly you are bravely raising your voices, standing for justice. Well, we're prosecuting them right now, are we not? Well, that's why we out here right now. That's why you out here. That's why you out here. That's why we're out here. Yeah, but we don't want you to be hurt. We want you to raise your voice. You know what, brother? You know, I'm going to tell you, you got the mayor and the AG saying that we're going to make sure justice is done right here. I don't know enough. But what about the one being prosecuted now? Today? Yeah, we will. But we do know they're being prosecuted. We do know they're being prosecuted, right? So you know we're not going to just let it go. I'm telling you that it's not my case. It's in the hands of the Washington County Attorney's Office.
We're supposed to be upset with. He's trying to make us understand.
Not at all. Not at all.
You don't know that.
Hey, this is a brother. Hey, this is a brother that's trying. Hey, this is a brother that's trying. When you use the word rhetoric, just know you ain't getting the rhetoric. You know, I'm a rhetorician. Hey, I appreciate you, man. I just want everybody to stay real, stay good, you know, for sure. Just stay behind this box and get that safe distance. That's all I ask. There's no way.
That's a mirror right there.
They got us stuck over here.
Well, thanks for sharing.
Yeah, and he refused to talk to media or press.
Really?
Yeah.
Thank you so much.
Oh yeah, no problem, man. No problem. Yeah, it's all good. It was just around the corner.
Dope.
Yeah.
He was a pre-submissive?
Yep, hell yeah.
Cool.
Yeah, I think they're about to spin out of here soon.
Nice.
Good time to get the phone back. You know what I mean?
Right.
Gotta get that.
Right.
I'm glad someone's getting their phone back.
Oh.
Right.
Did you just find it on the ground?
Yeah.
Nice.
Yeah. It's like, well, how do we get it back to him? And then they called. Yeah. But that was just some video that you all saw of Keith Ellison and Mike Elliott. Mike Elliott is the Brooklyn Center mayor. Keith Ellison is the Attorney General of Minnesota. And they were talking about getting justice for Daunte Wright, going through the process to get accountability against the officer. Has the officer been named yet?
No, I don't know.
Still not named. Yeah. On paid administrative leave, not named. Mistook their taser for a gun, or gun for a taser, and killed Daunte Wright.
All right, hey everyone, thanks for tuning in. This is Dan at Unicorn Riot. That was Nico's footage from April 12th. That was the night after, the second night after Kim Potter killed Daunte Wright. That was before Kim Potter's name was even out there. So thank you all for tuning in. We heard earlier from Stephen I. James, and then turned up evidence, if anyone still hasn't heard who was following the stream. We found that this man has been using it on this website called Sturmgewehr, using the username AutoRidge. The defense witness has been using this account to seemingly sell weapons that are closely regulated by ATF. This is kind of the upper end of what's available to sell in weapons in the United States. So his email and phone number match from official documents that are hosted on mncourts.gov. It's the same email and phone number. So that was a kind of shocking little thing that we discovered about the witness who was on today. So we've got that. So I'm going to go down for a little bit. We've got court coming back in a little over 15 minutes, so we're going to kind of give it a 10-minute break. Thank you all for joining us. We really appreciate the support. This is Dan at Unicorn Riot. We've had Nico helping out back end, dealing with clips, things like that. So thank you all for that. I think iJames was done. It sounded like it was done. So I believe they'll be going on to another witness, but you never know. There could be motions when they come back from lunch. There's all kinds of stuff. The defense seemed pretty defensive when the prosecutor's use of force expert, Seth, was testifying yesterday. They seemed quite defensive because it seems like maybe they've kind of broken through to some extent, or maybe that kind of has shifted the case more against the defense. But we did hear Kim Potter is going to testify. She did confirm that in court, so that could happen at any time. Could be this afternoon. We'll see. So stay tuned, everyone. Thank you all for joining us. We'll be back in about 10 minutes or so. Appreciate your support, y'all.